appeal without certified copy. The order passed on 13th of 11.
Appeal.
Group 7 appeal. Leave may be given to prefer the appeal without certified copy. Applied for that has not yet been obtained. But I have applied for. There is some urgency because same type of matters is going on in the single bench. Identical matters that has to be. I need to obtain a stay. That's why day after Monday, the other two matters on the same grounds, that has been taken before the single bench. So I need to, unless the appeal is preferred within that time, I cannot say also, date of the order 13th of November 2023. Group 7, before mine. I have annexed this. My lord, that I have given.
My lord, with the leave of my lord Justice Supratim Bhattacharya, my lord, I am mentioning one matter. Your lordship was sitting in the division bench before vacation with my lord Justice Harish Tandon, my lord. That motor vehicles matter, my lord, where the union leader has stopped my bus, my lord. They filed a report through the SP, my lord, that there is no disturbance. But my lord, in the vacation, again, the bus has been seized by the union leader, my lord. And the matter was supposed, my lord, it was supposed to be listed after vacation. There was a returnable date fixed, my lord. Matter has not been, my lord, listed till today, my lord. I have mentioned, my lord, they are not sending the... Before your lordship. Yes, your lordship. This bench, your lordship. Kindly, my lord, let it be taken as early as possible, my lord. My client is suffering losses, my lord. And the driver and staff, they have been heckled and they have been, my lord, physically assaulted. They were even admitted in the hospital, my lord. My lord. Kindly fix it. Grateful, my lord. Much obliged.
May I permitted to mention, my lord,
Yes.
one central administrative tribunal matter hearing. My lord, the matter was appearing before the Honorable Justice Tapapoto Chakraborty and Honorable Justice Parthasarathi Sen as an upgraded matter due to extreme urgency. Lordship.
Yes, then you give it. They will check if it was on the list.
Lordship,
then it will come.
Kindly, one of the petitioner has been twice attacked, cerebral attack.
Twice?
Cerebral attack. They are senior citizen.
We are saying if it was on the list, it will come. Just give it. If you said that it was already taken up. So if it was there, it will
change of
come.
determination.
Then you give it. If it was there, it will come.
Or may I be permitted to mention, my lord?
I don't remember.
May I be permitted to mention, my lord, 4 matters, my lord. The judgment was passed by your lordships. The difficulty is this, my lord. The orders have not yet been uploaded.
Which one?
WPST 215, 216.
Number will remember.
But this is the matter where the NOC matter, my lord. The judgment has not yet been uploaded.
It should have been last night. Just see.
No, my lord, I have checked it.
We are telling you, just see. Just wait. Yes, all that.
My lord, the appellant is a senior citizen and trespassers are creating problem in his own premises. The matter is pending from 2021 and
What are you mentioning here?
my lord, it's a assigned matter. It's has been released by Honorable Justice Harish Tandon in his personal ground, and then it was in hearing stage and assigned to the Honorable Justice Supratim Bhattacharya. Then it comes to your honor's court, but it is released. My lord, kindly, it's not released. It's kindly let this matter be listed, my lord.
Matter? What is the matter? Just show us. It's a first appeal. Now that determination has changed. Because earlier we were dealing with that. Just check if this is a assigned matter. We don't think it is a assigned matter. Just take the number and find out if it is a assigned matter. FAT Yes, call the list.
List.
Item number 1,
That's why he said.
It's a matter regarding reservation in promotion. If you
Only
lordship.
now we have to see the section 20.
Well, I was of a, but I will be very candid. I was of a different opinion, my lord, because at that material point of time, the disputes possibly relates to all time before 2015. The act came in 2016, subsequent act. So that is also an issue whether, because his right accrued,
Okay.
that is,
Section 6, General Clause Act.
my lord, that
So
is also a point we should.
then whether, what is your submission? He says right accrued prior to coming into force of the 2006 Act because he was declared, what do you call it? Decategorized. He was decategorized in 13, if we remember correctly.
30.
That was much before the Act. So section 47, there is a recent judgment.
47, my lord, is 95.
There is a recent judgment of the Supreme Court
Huh.
regarding the applicability of this Rights of Persons with Disabilities Act. Which act will prevail if the right has accrued before coming?
Well,
with
I was
reference to
trying to.
this act itself, with reference to this act
Well,
itself.
there were several, possibly I may have missed it because those the recent judgments are on. I could not find any judgment on promotion. Mostly these are of medical admission to medical colleges. Recent judgments of Supreme Court, there have been various judgments where benchmark disability has been
That
discussed.
judgment of his Lordship Justice Chandrachud sitting with Justice Surikant and one more judge. TRP matter on account of some mental disability. He was
That possibly I have a judgment of Patna High Court, possibly that they have concurred with the previous Supreme Court judgment which I had placed. Maybe this went up in appeal, quite possible.
no 2020.
Mental disability, my lord.
If I remember correctly, 23-2 SCC 209. I'm asking brother to check. If you have a system, can you check? 23-2 SCC 209. Because the same question with respect to the same act, therefore, it may be relevant for us. Ravinder Kumar Dhariwal, yes, I think this is, yes.
My lord, can you give me some time because I have to set up the network. (23)2 SCC 209.
Referring to section 6 of the General Clauses Act, the Apex Court in that judgment has said exactly what you submitted, that if the right has accrued, therefore, when you said it clearly struck us that yes.
No, if your lordship, my lord, I was not referring to be very honest, I was not. If your lordship,
The principle.
no, principle. Principle in another judgment before lordship sitting with my lord Justice Tandon, railways, my lord, absorption matter.
Yes.
There this issue came up. Whether I was relying on a subsequent memo. Your lordship,
This is with reference to the same act. You will find it.
my lord, I will find. SCC. Paragraph 18 and 19 possibly, my lord.
Nineteen,
Right.
exactly what you have
19.
submitted.
Well,
So then we should apply the section 47.
I have talked to the department, my lord. They have said our main difficulty was giving effect to it. They had paid the, otherwise, my lord, my lord, they are also of the opinion that we should not have done this mistake. It was a mistake, but yeah.
Well, then nothing is to be argued.
I would like to refer to one judgment.
Please.
Power of railway board to frame rules, because master circular was by railway board. So what this judgment says, this my lord, AIR 1969 SC 118 VS Vadra versus Union of India and others. It says the railway board's order has the force of 309.
We have not disputed.
No.
Not an issue.
So since
Not-
I am heavily relying on the master circular,
So we asked you to find out only whether it was still in vogue.
Very
They
important.
have, when there is no dispute, we need
Yes.
not go into that.
Yes.
If they were saying that it does not vest any right, you cannot rely upon, then that issue may have.
Section 47 read with railway board circular, this man is entitled to GP of 20.
That we were just wanting to see whether which. act-
That was,
so
my lord.
that issue is-
Subsequently,
Now that
my lord,
issue,
even there is,
I
there,
didn't recollect this judgment on that day when you made this submission. You have a bad memory, so many cases coming every day. Then nothing is required to be done.
No.
Right. The clarifications having been sought.
at least your lordship remembers judgment, my lord.
Sometimes I'm very bad with this. The person, disabled and you have to provide them. Just like you know. Send it.
Item number 2.
My lord. My lord, I have heard the application, my lord. My lord, Mr. Mozumdar is appearing. His clerk left the brief, my lord. He was here, my lord.
Today is, we will not
Kindly-
adjourn it again. I'm sorry.
And as a last chance, my lord, kindly one day, my lord.
Oh, sorry. This is not the
Then,
way.
my lord, kindly make it short passover. My lord, he will come. He was here, my lord.
Ask him.
My
This
lord,
is
he
not
was
the way.
here, my lord.
Yes,
Just now left.
ask him to come.
Kindly take the matter at 2 p.m., my lord.
No, sir. You ask him to come. Please send word to him. This is not the way, sir. This is not the way. Sorry.
They can also.
He heard you yesterday and then after that. What is the matter? What was? Oh, aid to be provided to the school. We had seen this matter yesterday. I don't remember. Just refresh. Oh, it's a contempt. Page 36. Where is the order?
It's 33, if your lordships may kindly come to.
Oh, yes. So you have been afforded an opportunity of hearing and the representation has been disposed of. But you are not satisfied with the disposal. Your claim was for grant of aid,
Recognition with aid.
recognition with aid. And what have they done in
That they
compliance?
have granted me permanent recognition, but without that. Previously, not from 1993, I was enjoying this provisional recognition. This provisional recognition with recommendation went from the various levels of the government as well as the local authorities on the ground that there is inadequate schools or educational institutions in this backward area, which is predominantly occupied by other backward classes. Now, they come up with this, and on the basis of this representation and recommendation from the authorities, this matter had gone up to this various stage. This is the fourth round of litigation before this honorable court. Now, please come to the order which has been passed subsequent to the order of this honorable court at page 33.
No, let us see the court's order first.
Page 33.
Consider the matter independently on merits
My lords.
to grant an opportunity of hearing. This was the specific mandate,
Yes.
and at the time of considering, first, the financial benefits is to be considered. Second, is to be guided by the statutory provision, and third is the constitutional mandate. So yes, something.
Court has laid down the guideline. Not my point is these guidelines have not been followed. Please come to page 45. The findings. At page 45, under the broad caption findings, please come to the last paragraph of that page.
Yes.
Note the first ground is at page 46. If your lordships will kindly take note, this is really overreaching the honorable court's order.
The first ground is whether the benefits can be extended to organized teachers. That was the first guiding principle laid down by the court. That has been considered at page 45.
Yes, not
At page 46, the statutory provision contemplates existence of such schools without any assistance financially.
Good.
And the third is the Article 21A, they say we have already 2 schools.
no. This is a Kendro, Madhyamik Shiksha Kendro.
Yes,
But
whatever.
Be
but-
that as it, this recognition was already there since 1993-94.
So they have given you the recognition.
Right, but without an assistant. So not so far
But
as
earlier also you were not having any assistance.
I had been receiving this, I had been enjoying this provisional recognized status since 1993-4.
So now it is permanent,
Permanent.
but
So,
without aid as it was before.
yes. So not
So therefore, the validity of this order will have to be seen.
so not
There
the
cannot be a scope for any contempt.
so not the ground that there is existence of another school within a certain distance that goes to the backstage.
We
Because
don't know that we
They
are
have
not
granted
to,
me permanent
we are not
recognition.
to look into that. You have to realize the limitation of the jurisdiction where you are arguing the matter. That is all.
But today,
If we make any observation on this, then any writ or any other forum that you may have, it will become redundant.
today, we know, apropos Parihar's principle, that 96-6 SCC judgment,
Yes,
not the scope, your lordships have laid down the law, this is quasi-criminal jurisdiction. I'm not today that observation in this order, which says that because of the Expenditure Act 2005, it is one of the factors. But this is specifically where the court held that this financial alibi cannot be taken as a recourse for rejection.
you have never been granted aid or you are not in that category. You are
I
under
was never granted aid.
you are under section 2N.
I had never been granted aid, but not in spite of that, the court held at the time of disposal of the appeal
Yes.
that this financial alibi should not be a ground for rejection.
No, the financial aid cannot be an alibi for benefit.
Yeah, financial aid cannot be an alibi.
We don't know whether this is against them or against you.
Cannot be an alibi for the benefits to be
The
extended.
benefits to be extended to the organized, it will not be extended to organized because they are organized of the erstwhile private committee, managing committee. They are not government. So therefore, we are saying whether we should comment on the validity of the order in these proceedings. This first observation, it says this cannot be an alibi to extend benefits to organized teachers.
Right.
So whether it is in your favor or it is
Not reasonably construed, this ought to be in my favor.
so therefore that is an issue you should
Reasonably
argue.
construed.
You will be required to argue whether it can be done or not. The second and third, of course, they have dealt with it. If there is any scope for argument, it is under the first.
First says, at the time of consideration, the prayer for financial aid cannot be an alibi for the benefits to be extended to organized teachers, and any issue which stands judicially settled is not a subject to be reopened.
Not a very watertight, that you do it like this. It is giving a discretion.
But with this guideline.
Correct.
Now,
what is the meaning of that? This cannot be an alibi. Financial aid will not be an alibi to extend it to the organized teachers.
For benefits to be extended.
Yes, for benefits to be extended to organized teachers because
But
otherwise.
When it uses the expression financial aid, this has to be at the behest of the government which is issuing the aid.
It may be read otherwise also that in the garb of financial aid, you cannot extend the benefits to the organized teachers. We don't know. We didn't pass this order. We don't know, but we surely are of the opinion that case of contempt is not made out. That is the only limited scrutiny that we are doing of the order. All three aspects have been considered, maybe not to your liking, maybe as per you, there is a scope or it is incorrect. We don't know, it may be.
Other request observation against
I have the benefit of some voice from the earlier bench also. It is better you go to the report. You will be at liberty to assail the order. Heard the learned counsel for the petitioner.
Item number 3.
3 is 4.
Three. Oh.
Either the appellant or the respondent. Let the matter appear on Monday, 3rd of 2nd of December. Thank you.
Item number 4.
Here for that. Aside. Yesterday was there. Yes.
But the matter not just taken up yesterday, I will get to it. And the supplementary applicants. SAS. Section of this subordinate audit account service. Auditor to assistant auditor, sir.
In respect of a particular, your lordships have heard this matter yesterday, I believe. That there was an examination process for promotion conducted by the
What
authorities.
we remember, we'll let you know that SOG is subsequently renamed as SAS. A slight change in the modus of selection process also, now CBT based, and there were 2 papers, statistics and statistics sampling, which had been abolished, and the other one we don't remember. You have to tell us.
This is financial and contract management.
Financial and contract.
Financial and contract management.
So for the SSS, they said that now it is abolished, even if they have failed, it doesn't matter. For the other, they did not say so. This is your.
This is right. The 2 pages, please take note, page 60. I'm sorry, this is page 83 of the writ petition and page 18 of the
We have
supplementary.
seen the abolition of statistics and statistical sampling, but we have yet to see the abolition of the other.
Please see page 18 of the supplementary affidavit.
18.
Of the supplementary affidavit. Point number 1, in the middle portion of the page, the paper SOE 19 and SOE 31 have been discontinued with effect from the examination of 2010. But this paper was SOE 19. With effect from August-September 2014, main SAS exam, the syllabus has been revised to incorporate a component of the syllabus of statistics and statistical sampling in the paper PC2 logical, analytical, and quantitative abilities. Now the new syllabus is available in the CAG's website, so and so. So, my lord,
No, but this we cannot rely upon. This is just an information under the RTI. This is not any document showing the purpose, the policy, the decision. This cannot be relied upon to
page
either
20,
contend that a discrimination has taken place or to contend otherwise.
so please see page 23. My lord, this is what they have disclosed on my query.
This cannot be. We don't know what is the decision.
Not
Neither
this,
you know. It is just a roving kind of
it's
a.
their information.
This is just an information that this has been done. Why it has been done? What is the policy? Where is the decision? We don't know.
The earlier stand was it had not been discontinued. On that premise, my lord, the parties proceeded.
Where is that? That it
Yes,
has
please
not
come
been
to
discontinued.
the earlier stand was the paper had merged. Please
Let
come to
us
page 33, which is part of the reply before the learned tribunal.
So the other paper is SOE 17.
19. No, the other paper was I failed in SOE 19. The other paper was SOE 31. 30.
SOE 31 तक abolish होगी.
30.
And commercial auditing is not an issue.
No. 19 and 31, these are the two papers.
Yes.
So when the stand before the tribunal was the paper had merged. But now it appears that the paper had not merged but discontinued or abolished like the 31.
Discontinued but merged in this.
Please come to the reply once again. Pages 63 and
No, that RTI is, we will not, that is not Reliable. That's not reliable.
Not it, not, I show to your lordship not 3 stand taken by the respondent authorities. Please come to page 65 also.
Yes.
But this is part of the Office of the Comptroller and Auditor General writing to all the heads of the department.
Page 65.
Page 65, the document begins at 63. It is part of annexure P9.
All right.
It's a letter of 2010 issued by the Office of the CAG to all the heads of the department.
This doesn't say anything about SOE 19. This does not even have a mention of SOE 19.
So it says this was the policy. It would be deemed to have passed from the date of issue of this circular. Now, please.
No, SOE 19. We are on SOE 19. That is the only bone of contention now.
Right.
There's nothing more and nothing less. SOE 19 is not even mentioned in this. This only mentions that statistics and a statistical sampling paper which has been abolished. This does not talk about the financial and contract management.
So 18 and 31 of the supplementary affidavit, this clearly says that the papers were abolished. That paper was also abolished.
Whether that will be the stand of the authorities in the proceeding or the stand which they have placed on record will be the stand of
the stand.
Therefore, we are saying, see paragraph 11 of their WS filed before the tribunal.
Right. Not this, of course, is a stand put on record, but not apropos, not the decision taken. They have not disclosed the decision as of today.
Yeah, this.
It's a stand vis-a-vis the reply. I
could have asked them for the policy. You didn't. You asked them a query. They gave you an answer.
But they,
you could have asked them for the document. They would have given it to you.
Or only for that paper. And in any event, not same principle would have applied.
Whether it is true or not, that is the issue. That, of course, he had argued yesterday that once you have done it for the SOE 17, what is it? 31. You should have done it for SOE 19 also.
But when on record, at least on record, it is available that they have discontinued this. It is not a question of questions merging into this chapter or this syllabus like that.
All right. So let us see that. You want to rely on it, we'll see it. Where is that? Page 13, you said.
Page 18 of the supplementary.
No, there was a more elaborate reply which you were referring to.
That's 23.
But this doesn't say anything about discontinued.
It doesn't say.
Page 23 does not say anything.
Page 23 says 31 was discontinued. Not please consider this vis-a-vis page 22.
Where does it say?
Page 22, please come back to page 22. Middle portion, the paper SOE 19 and SOE 31 have been discontinued with effect from the examination of 2010. If a particular treatment is meted out to SOE 31 examination takers, then the same benefit should also be extended to SOE 19 paper takers.
So 18, and there is any difference between page 18 and 22, or it is the same?
Same document. Same document.
Why has it been annexed twice?
No, it's part of the enclosure. But it categorically says from August, September 2014, the main exam, the syllabus has been revised to incorporate a component of the syllabus of statistics and statistical sampling in the paper so and so.
That you are not concerned with.
No.
That you are not concerned.
Change it to 30, but
Your grievance is only the financial control and management. What is it? That is the
That's
name.
That's right.
Financial control. Financial and contract management.
Financial and contract.
Contract management.
Financial and contract management.
Contract management.
And but if your lordships kindly read that 2010 policy, but I have placed that paragraph H from page 26. Please come back to page 25. Now, this is the background. Page 25, paragraph 7. The revamped subordinate audit or account service SAS examination has 25 of the supplementary application.
Supplementary. What is this document?
This is the 2010 policy.
It is the same. We have just
Same.
gone through it. Let us see in that rate petition only.
Very good.
I've already marked it after reading.
sorry.
Therefore, we would rather that you refer to this P9.
Please come to paragraph 7 at page 64. I'm sorry. Please consider from paragraph 6 onwards. A maximum of 6 chances would be allowed to the departmental candidates to pass all papers of the respective examination. The counting of number of chances availed would start afresh from forthcoming subordinate audit or account service examination, so and so examination of the year 2010. The revamped subordinate audit or account service examination has following features. My lord, subordinate audit examination would be conducted under 7 different streams. Note the streams are mentioned. One of them is commercial audit, defense audit, so and so. B, the whole syllabus of subordinate audit or account service examination has been divided into 2 groups, group 1 and 2. Each group consists of subjects or papers as per annexure I appended herewith. It would be possible for eligible departmental candidates to appear in both the groups simultaneously, subject to any restrictions relating to mandatory training requirements. The maximum number of chances is limited to 6, as already prescribed in the preceding paragraph. A candidate who registers himself or herself for any group in a given year would be treated as having availed a chance to pass the SS examination for that year under normal circumstances. So, not this paragraph 6 read with paragraph 7 with the subparagraphs thereunder, where it refers to papers and the maximum number of 6 chances being made affordable to a candidate. Now, this will only render the exercise to be odious if a non-existent paper is made a condition precedent for passing the examination.
So therefore, there are 2 limbs of your argument. One is that their action is discriminatory. They have abolished one paper. They have said now even if you have failed, you are not that you will be deemed to have qualified. For the other, they have not done it. Second is once they have abolished, how can one qualify that?
That's the point. But this document read holistically leads to an irrational conclusion.
But
If
this does not say anything about SAS SOE 90.
It doesn't say, but not, if your lordships kindly consider paragraph 6, paragraph 7, paragraph 8
Correct, correct. That is
in
there, that-
juxtaposition, then not this may lead to an irrational conclusion.
Yes. This does not govern the subject that you are saying, you are arguing about. This will not apply. This is a general scheme of the examination.
Right. Not
And a reference or an example has been given in
that paragraph, particular
H,
paragraph.
in
H.
paragraph H, that
Yes.
is regarding statistics and statistical sampling. Not example, it has specifically.
Specifically said only. Only.
That is the only one which has been mentioned. We don't know the syllabus 2010 that you have not brought on record. There is
No,
nothing.
it says that paper is abolished. I mean,
But that
the
is-
stand is paper has merged.
That is not the syllabus.
No,
Their,
that's
their stand now is that now it is merged. So what they are, yes, what is your contention? Why should we say what your contention?
It's not exactly that, my lord. But this is not a promotional examination, my lord, for any promotional post.
For
Any promotional post, examination for promotional post.
if they pass the SAS, what will they become?
Well, they will confirm their service.
Confirm.
Probation, yes.
No, we will become from auditor to assistant audit officer.
It's not a confirmation. It's
Yes, my lord, they are on probation. When we are during the probation period for 2 years, they are supposed to pass the SS examination, my lord, by 6 chances, my lord. If they fail to do so, my lord, they can be removed from service or can be employed in a suitable post. My lord. I am giving them a relevant rule, my lord.
so this is not for career enhancement.
No.
But if you qualify, you will go to a particular stream. If you don't qualify, you will be sent in another stream.
If not really, if not really. It's rule 5.5.2. And carried out. Rule
Just
5.5.
just a minute. So for section officers, this exam is for section officers.
Direct recruitment. My lord, according to since he failed, my lord, the recruitment failed, he was relieved from the section officer post and offered the post of auditor. He accepted it into 2010, my lord, and after serving there for 3 years, he came to the London.
Oh, so as a result of not qualifying this examination, he has already suffered the consequence.
The front page is the one.
And without you raised any objection while you were being asked to work as auditor.
No.
Please,
Please-
3 years only in the.
Please come to page 21.
No, just see the provision, the rule which you are governing your service.
Not, I took 2 examination. The first entry,
That's not the point. The point is if you have not qualified the SAS examination, your rule governing your service says either you will be removed or you will be asked to serve as auditor. Now you have been asked to serve as auditor because you did not qualify. You have already
that's under
availed that.
challenge.
That
That's
you have
under-
never challenged.
That's under challenge. Please come to my prayers.
He served there for 3 years.
Have you raised an objection at the time? That is what we
No,
are
that's
asking.
that's not on record. That's not on record.
No, have you said so?
No, that's not on record.
Then how can you?
Mm.
You cannot.
Accepted the relegated post, my lord, served there for 3 years. And then he came.
Give her of the impression that it is for a career enhancement.
No, it's, please come to their stand, not at page 33.
No, whatever is their
Coming up with a
stand.
new stand every time. No, please come to page 33.
This is a rule which governs your service. You can't say a new stand. You have availed the benefit of this rule by being continuing in service as an auditor. Otherwise, you would have been out.
No, I would have been reverted to the original post where I had.
No, the rule
Please come to
says
page, please
the
come to page 21. But
Just-
I joined the direct recruit post in 2004.
what it says, he, she will be removed from service. This is the one consequence. Or if fully deserving of retention, may be offered appointment as an auditor. You were not removed, you were considered fully deserving for retention, you were offered an auditor and you have taken the auditor in 2010. 2013, you say, why didn't you exempt me? Very peculiar. This is the rule. This is governing your service. These are the standing orders issued by the CAG. You cannot, this aspect has not been considered by the tribunal. See the tribunal's order.
Is a question that 5.5.2 says direct entry into the cadre of section officer. But I entered into the cadre of section officer in 2004, not the 2009 examination was the subject matter at that point of time.
That's immaterial. This doesn't talk about 4 or 9. This does not make a distinction regarding 4 or 9.
So, cadre of section officer will be on probation for a period of 2 years.
Yes.
So, please come to page 21.
The point
I
is
joined as a
whether-
direct recruit section officer on probation in August 2004.
Whether you joined in 4, 6 or 9, within 2 years, this rule required you to pass the SOGE, which in 10 become SAS. Therefore, the SOGE you were required to pass within 2 years by 6 itself.
Right.
Now
Into-
you did not pass by 6 itself.
I passed the section officer grade 1 examination in April 2006. Subsequently, he appeared in part 2 examination in December 2006 and got exemption in some papers.
SOGE part 2 you are required to qualify.
I got exemption in 4 papers.
That exemption is only because you can appear in the next exam. Those papers which you have passed in the last examination, those are exempted in the next exam.
Right.
That is the scheme.
No, that apart also some papers were exempted. Now, please come to
How can you raise this issue? This is a stale claim being made by you. Don't have any claim. If at all you could have raised it in 6, 7, 8, 9, 10 for 6 years under the SOGE while you had appeared. You wait for the new scheme to come and then you all of a sudden turn around, having taken the advantage of becoming an auditor, say that now by virtue of this rule, you can't, your maximum chance lapsed in 2 years. Where's the question of appearing in an exam after 2010?
in May 2009, the examination was conducted, the part 2 examination.
But sir, you had to appear within 2 years. In
So the
2006, your chance had already lapsed.
2006, I appeared in one.
Yes.
The next examination was conducted in 2009.
Yes.
Part 2 examination. In 2009, I appeared with exemption in certain papers,
No,
but failed in one of the
there is
subjects.
some ambiguity. 5.5.2 says
Right.
that you will be on probation for 2 years.
Right.
And during probation, you have to qualify SOGE too.
Part 2. So this
Correct.
part 2 examination was conducted in 2009. I passed the part 1 examination in 2006.
Yes.
They conducted the part 2 examination in 2009. I failed in one of the subjects.
Yes.
Now, this says that that 2010 policy came subsequently.
Where have you said that between 2004 to 2009, there was no examination?
Please come to page 21.
This was your case.
And I pleaded that before the Learned Tribunal that I had been reverted by reason of non-passing of.
For reversion, we are talking about examination.
Yes, please come to 21. 4.1. The applicant joined as direct recruit section officer in August 2004. He passed the examination part 1 in 2006. Subsequently, he appeared in part 2 examination in 2006 and got exemption in the following papers.
You appeared in 2009
Now-
and
now
there
please-
was no examination. There are two different things.
Please come to 2007. That VDA circular of 2007 from November 2007 syllabus for commercial audit branch were changed, and from November 2007 to 2009, the papers for SOG examination were as follows. Then please come to the next paragraph.
Yes.
That as per the new syllabus, effective not E and H, these were the two newly introduced papers.
Don't know how you are allowed
In
to
part 2,
appear
your
in
lordship has found that
2009 examination. It is very
2007 newly
not
introduced.
your case that no exam was conducted.
No,
It
these
was
were newly
changed.
introduced and examination taken in 2009. Newly introduced syllabus.
You nowhere say that no examination was conducted.
These were exempted.
Exemptions kept coming and
Yes.
going, but exams from the pleading, it appears that based on these exemptions or these alterations, the exams were being conducted. It is nobody's case that no exam was not conducted was till 2009. Whether you were eligible to take this exam in 2009.
Because I took this examination only after the change of syllabus in 2007.
You may have. We don't know how they allowed you if you're supposed to do it within 2 years.
That as per new syllabus,
You to take the exam after 7 years, that itself is very peculiar. The rule is very clear. It has to be done within 2 years while you are on probation itself. So how you have been sitting for these examinations and whether any right will accrue, that is also another aspect. It is a specific if a direct recruit fails to pass both parts within the period of probation. Within the period of probation, and period of probation has been defined as 2 years. Rule 5.5.2 is clear. So whether you can
it says both parts have to be cleared.
within 2 years.
Not 5.4, it says within 2 years, of course. Not
Yes.
2 years is the probationary period. Every direct recruit will be on probation for 2 years. During the period of probation, he will have to qualify SOGE part 2.
Yes, within 2 years.
Right. Now, not,
That means 2006 for you.
not the pleading says 2006, not there. 2006, it was my last date. 2007, there was an examination where I participated.
After the last date, whatever happens, how does it concern
I'm sorry,
you?
2006, it says. Subsequently, he appeared in part 2 examination in December 2006.
All right. So
And
after
got
that,
exemption in the following papers.
you may have got exemption because earlier you had passed the other papers.
So that is probably the.
But then after that, you have no right. You have no, you cannot raise any issue to what happens after 2 years. It hardly affects you. That's what we are trying to understand.
Not that I took the 2006 examination with the exempted papers and was not disqualified.
We
Is
don't
probably
know.
an indication that I had been confirmed on the
The rule
post.
does not say so. We don't know whether they are required to scrutinize applications and allow only such person to take the exam who are within the 2 years, or anyone who fills up the exam can sit for the exam. We don't know these facts. And maybe for those who have not done it within the probation period and have gone to the auditor side, even if they qualify subsequently, it may inure to them their benefit somehow or the other. We don't know. These issues are not here. But for the purpose of your retention in service and appointment as auditor, this was to be done within 2 years only. After that, it may be having some further consequences.
Auditor was offered to him on 12th of January 2019, 2009. And he accepted it. He accepted
But I
it.
joined as
Out there.
but I joined as a section officer. I could be confirmed to the post as a section officer. Auditor is a different post.
Oh, no. 5.5.2 is more than explicit.
Right.
It is more than explicit.
Section officer.
Please read the entire 5.5.2.
Every direct recruit appointed to the cadre of section officer will be on probation for a period of 2 years.
Please complete.
During the period of probation, he will have to qualify SOGE part 2. If a direct recruit fails to pass
If he fails, then what happens? Just
both parts of SOGE within the period of probation, he will be removed from service, or if fully deserving of retention, may be offered appointment as auditor in respective office
so you have
against a
taken that.
direct recruitment vacancy if
You
available.
have elected that option. You have exercised that option.
But it says that in 2007 I passed the examination.
You may or you may not, but that is over.
Not, this is uncontroverted at page 21. Pleading is uncontroverted by the authorities.
We are not concerned. We are seeing the rule. It's not an issue of fact. This is a 2-year period provided in the rule. It is also not your case that you did not go in the auditor side. So it is as clear as daylight that this
So I
has
had
been
the
applied.
auditor.
So
channel.
this has been applied. The facts are speaking for themselves. So we don't know whether there is any further benefit which is contemplated by virtue of passing this examination at a subsequent date. Maybe somewhere in these rules or some other rule, some other standing order issued by the CAG, there must be something.
Please come to their stand, page 35. 4.1 to 4.4 is matter of record. That's all they say.
That's not, they're not required to controvert anything. It's a statement of fact. It doesn't say that you were taking these examinations for the purpose of permanence as a section officer. It just says you were taking examination. You are writing the examination. That is all it says. So it is a matter of record, which is correct. If you had in any case indicated that we were still being considered for being retained as section officers, for that we were being allowed, and therefore is to be looked at that way. That's not your case. You were appearing, but anyway, even if you are appearing, the issue remains the same. Whether you can raise this issue, what is the benefit? Have you said in the OA that by virtue of, even if you are granted the exemption, what will be the benefit to you?
But if I'm granted the exemption in respect of part 2, probably this may have two consequences. One, I appear in the rest of the papers which had not been exempted from appearance, and I clear part 2.
So if you clear, then what? What will
Then I
be
get
the-
confirmed to the post co-probationer.
How can you? You have already gone into the auditing
That's-
section.
5.5. If I am granted exemption, so minute I pass, I clear the part 2 examination.
There is nothing on record to show that by virtue of such qualification, you will have this benefit and you are being deprived of this benefit because you are not being able to qualify in this examination. There is nothing. It's an academic question appears to be. What is the benefit that accrues to you? Can you show from the OA? An audit be issued declaring them pass. Then for what?
Paragraph 4.6 says at 23 that the applicant made a representation to the authority concerned stating inter alia that he joined in the department as a direct recruit section officer on probation in 2004. He passed part 1 in 2006.
There is nothing.
He got
How this exam will benefit you in what way? What is your deprivation? Nothing. An academic issue appears to have been raised by you, and the tribunal has deliberated upon it, and we are also deliberating upon an academic issue. Neither any deprivation is spelled out by virtue of being not qualified, nor there is any benefit which you claim by virtue of this examination. Whose cause you are espousing, your own or somebody else, we don't know.
No, नहीं.
That is under this scheme. It is right here, page 63. Here. At the- Page 65. B19 under the SOG. See how you describe yourself, your name in the application at page 20. You are in the audit already by virtue of application of the rule.
Yes, not
So
that-
what is it? What
that
is it you
having-
want to achieve? That we are
the only sentence that I find is he was reverted to the post of auditor. So probably a lesser
there
pay.
is a question of reversion.
Because
And
of-
where is it that if you do it now, you will come back?
Of course not. This ought to be a question of confirmation, not reversion.
Because otherwise it becomes an academic issue whether we should deliberate on this or not. Anything to show that there is any benefit which you claim by virtue of this exam.
But apart from that word reversion, there is nothing.
Where is that reversion body?
But that's page 45. I'm sorry, that is at page 26. No. I just missed that page. 23. Please see not
Page para 4.6.
4.6.
He was
Was
reverted.
reverted.
It's not reverted. He was appointed as in the post of auditor. There's no question of reversion.
Legally to
These are two avenues as it appears from the rule. There's no question of reversion. Reversion would be if it was a lower post carrying a lower pay, or by virtue of acquiring this qualification, you will overcome that reversion. Where is this?
let's see. Section officer was a higher pay, auditor was a lower pay.
Maybe.
That's but this appears to be a separate appointment for non-passing.
Yes. It's not a demotion or reversion. In fact, it is a privilege by finding you to be worth retention. Otherwise, you would have been out. So it is a benefit granted to you by finding you worthy of retention.
Now, but if I may try to put it in this way, but I had been appointed to the post of auditor in 2010
On probation.
on probation. Section officer on probation failed to pass the examination in 2007 to 2000 within 2 years. That appointed me in 2010.
No.
Doesn't take me.
Can't be.
Doesn't take me out of rule 5.5.
Yes, it doesn't take you out. Doesn't. Third Leonard. That will be all. Third
If
Leonard.
I may
Academic issue is the writ court.
argument করার পর কি
Anything else? You are being prompted to say something.
Prompted to say that. I think we'll have one discussion with him.
All right. Not today, that's all.
Very
Oh, as prayed by petitioner's counsel.
good. এর মধ্যে বুঝতে কি করে বুঝতে পারবো না
ঠিক আছে চলো
Item number 5 to 24.
আজি ছেড়ে দিন
আমারও ইচ্ছা হচ্ছে তুমি না বলো আমার তো এই যে একটা নিজের মামলা এই যে একটা নিজের এই যে একটা নিজের আমার এই যে আমার Met with the church. And now for the petitioner, my lord. Would you kindly cease, my lords,
How many writ petitions?
earlier ordered at 11th of September. Sorry,
So
no,
many writ petitions.
yes.
Relating to one, only one, and other ones individually they are.
All these, my lord, are casual employees. Kindly cease, my lord, 11th of November once. For interim stage, what was, my lord, pleased to pass this order. 11th November.
Yes.
That is the speaking order, my lord, that is page 11/2009, 194.
You're for the Union of India.
Union. In this
You have
matter,
seen the
my-
last order. You have seen the last order.
Yes. But this matter, my lord, you not directed to take a copy of the
Rules.
and the other thing about this rule, my lord, that you have brought. Now, question, my lord, in this matter, my lord, is regarding the
Earlier file. Earlier file.
Specific rule to
I have got zero. My lord.
So there is no dispute that one set of ad hoc has been arranged with the other set of ad hoc.
Now, question, my lord, I have gone through the petition, my lord, vividly between the word of this petition. And my lord, if your lordship allow me to adopt the reply in the tribunal, my lord, wherein my lord, there has been elaborately discussed the matter and the judgment was based on that. Your lordship can see the question raised in this matter, my lord. Apart from, my lord, that your lordship will allow me some take other instruction from the DDA. I have not yet contacted the DDA, Doordarshan Kendra of Calcutta. Only, my lord, if you would allow me to place the reply, my lord, it will be revealed that everything has been dealt with.
No,
We try to adopt, my lord, we cannot beyond that.
we are asking you preliminary thing is whether there is no dispute that these were ad hoc persons and they have been replaced with ad hoc persons. On this, there is no dispute. Is there any dispute?
Lord, they have not appointed or engaged, not question of appointment, engaged against the sanction post that has been replaced.
We are not asking you that. We are not asking you that. They were ad hoc engaged on ad hoc basis. That is what they are claiming to be. They are not claiming any better status. But they are saying that By removing us, they have brought other people who are also working on ad hoc basis.
Removal, my lord, from the agency, they have.
So they were
directed
earlier
that-
working through agency.
That has been, my lord, I have placed, my lord, what is the agency scheme for?
All right.
So engagement of the, that has been scheme has been framed.
No, but last day there was a submission that it is based on the general financial rules.
So, my lord, that financial rules I will controvert, my lord. The rules, my lord, that is not that. The
No,
scheme
that was your submission. That it is pursuant to a policy decision based on the GFR. So which provision in the GFR you are referring to?
financial rules, my lord, this question, my lord, that has been adopted. If it is made by me, that is then I have to admit, my lord, that is wrong. Because, my lord, your logically the Posarbhavati rule, my lord, the Posarbhavati scheme was framed. I am placing the Posarbhavati scheme. May I admit it? Your logically see what the scheme for
Okay.
page 183.
They are working, they are working since when?
1992.
No, 92, my lord, they are engaged.
I
Not
said work.
at a stage.
We asked you working, whether by virtue of engagement, by virtue of appointment, we didn't say. We asked you they are working since when? He is saying 92. Is that fact disputed?
Question, my lord, and not at a stage. Sometimes they are engaged.
All right,
and
so
then
not
subsequent-
continuous, not continuous.
Then will not de-engage. Subsequently, again, by virtue
All
of
right,
your
understood, not continuous.
not continuously, they have
183.
page, your logically sees the scheme for regulation of irregular. That has been, my lord, framed. Page 183. This scheme, my lord, in terms of the, my lord, the parameter laid down by the Honorable Supreme Court.
We are not on the issue of regularization.
I got understand whether they have rendered the service continuously or not.
No, we are not.
that.
We are not on
There
the.
was-
We are not on the issue of regularization. They have come in through an agency. That is your case. That they have come in through an agency. That is your case. Now that agency, whether it has been replaced by another agency or not, that is the only issue.
Subject to correction, no. May I very, my lord, take your lordship 30 seconds time?
Yes.
And then, my lord, senior will be asked.
Yes.
But the point of discussion was one, regularization, it was rejected. And during the pendency of this regularization claim, my lord, so that we could be working in that particular ad hoc posts. That was the point. When this matter was earlier taken up by this honorable court, I prayed before your lordship, my lord, since they said that they wanted to file some affidavit or something. I said that during this interregnum, I maybe, my lord, continued. I cannot be replaced by the new set of ad hoc employees. So, my lord, that was the point. I placed the judgment of this honorable court, and then my lord was pleased to, my lord, direct them that what was the position of the in the GFR rules.
Yes.
So, my lord, our stand was we were never engaged by any agencies. We were directly engaged by the Doordarshan itself, and they are trying to replace us by the agency.
Yes, 183 is on regularization.
One question will regularization, and second part, my learned friend, they will be allowed to continue in the such and such, that part, my lord. But your logically sees the Admission, dear Lords, kindly see me. I am placing on the page 294. It will be revealed 294. Middle portion, your Lordship, kindly see the OA 992 of 98. Application was serial number 60, paid for entitlement conferment of temporary status and terms of such and such dated 10/9/93 on the allegation that respondent of in spite of various events have not been passed any order confirming status, temporary status to them, and the direction giving the respondent confirm the temporary status to the applicant such and such. The OA was allowed directing the respondent authority to consider the case of the applicant for the conferment of the temporary status, further directed the complete exercise the period is the period of 3 months, and the respondent authority thereafter moved an application being such and such before the Honorable High Court at Calcutta on 2000 and was pleased to uphold the order of the Honorable Tribunal, directed the respondent to act in terms of the direction given the Honorable Tribunal. Being agreed by Milord dated 16/9/2004 WPCAT, such and such respondent authority move a SLP, such before the Honorable High Court, was pleased to pass an order with observation that tribunal order was clearly untenable, and the order of the High Court at Calcutta was error in proceeding under assumption of that protection given to some parties in Mohandal case applied in that case of the present case. After lapse of 15 years, logically see, the applicant again before the Honorable High Tribunal, being a number such and such, challenging the office order number such and such, 2019, further with a prayer for order or direction upon the respondent authority to allow the petitioner to continue their service at the present position and release salary month by month. And said OA was disposed of with observation that applications are apprehensive of losing employment on account of engagement of HR agency and for non-payment of wages thereafter. Hence, the applicant has given liberty to prefer a comprehensive representation, citing rules and judicial decision, and the respondent shall decide in accordance with law. But but the order dated 1/7/1919 was interfered by the tribunal. Now the issue is find out that the content of the office order 1/7/19, the office order dated was issued by the Procedural of New Delhi for approval of the allocation of fund under of the sub-detailed head of his expenses for payment directly engaged casual laborer, daily wages laborer engaged by the Durashan Kendo, Calcutta. It was stated therein that present dispensation regarding the mode of engagement of 33 laborers allowed up to July 2019, and Kendra was directed through the said office order dated 1/7/19 to switch over the mode of hiring, geologically market, mode of hiring of casual laborer through HR agency by inviting bid at per provision of the general financial rule through the GM, and to finalize entire formality by the end of July 2019. And DDA Calcutta was requested to kindly project the requirement of manpower to be hired through the GEM from 1/8/19 for further approval of the directorate. The applicant submitted their proposal, a personal representation of such and such, direction the honorable way in such and such. In the meantime, my lord, a scheme for regulation of irregular appointment and engagement in Procedural is pursuant to such and such brought to on 22nd August 2019 as per parameter laid down by the Honorable Supreme Court of the such and such Umadev. In the said scheme, my lord, there was a parameter for determining the eligibility for regulation, that is regulation, as mentioned in part 2 of the scheme, who had 10 years continuous service against duly sanctioned post, but not under cover the order of courts or tribunal such and such 2006. Again challenging the office order dated such and such 1/7/19, as well as the office order number dated 14/11/2019, along with the other prayer for regulation of the service, and the said way was disposed of on such and such with the direction upon the respondent authority to examine the representation made in response to the scheme dated 22nd August 19. On 12/12/2019, Procedural issued a letter for finalization of the tender such and such July for awarding contract of hiring 33 casual laborers for engaging. The applicant, along with the others, came before the Honorable Tribunal dated with a fair direction upon the respondent authority so that application in response to the regulation scheme may be allowed to be submitted on the ground that applicant could be not file within the time. Honorable Tribunal was pleased to pass necessary order directing the respondent to duly process their case in accordance with the policy invoked for after receiving the document submitted by the applicant, and shall pass appropriate order within it. In view of the order such and such, my lord, dated, the respondent also issued speaking order 20 July 2020, stating the details therein that on scrutiny, it has come to note that all 33 casual laborers, market, do not meet the following eligibility criteria for regulation against the duly sanctioned, but not under the order of the court of the tribunal, therefore non-fulfilling the above condition reverse all casual labor under the same scheme regulation, and the speaking order was passed in compliance with the direction of the such and such. The applicant, along with the other, filed several ways for the respective applicant being number such and such, and other ways challenging the speaking order dated 20th July 2020, and the said way, the applicant claimed that by virtue of the circular dated 5th September 2019, they are eligible to be considered for regulation having served more than 20 years. But the respondent authority denied regulation on the ground of the applicant not working under the sanction post, which is mandatory requirement under the same scheme regulation 30th September 2020. Honorable Tribunal was pleased to pass necessary order directing the respondent authority to constitute a committee to examine the service of the applicant particulars of the applicant to ascertain whether they have completed 2006 in consecutive 2 years and completed 10 years to be entitled for regulation in terms of the circular such and such. Let a report be produced by 4 weeks. It will such time till such time if the applicant are discharged their duty, they shall not be discharged till next date. It was till next date. It was also on record in the said order that respondent author submitted that department having no sufficient fund, your lordship market, no sufficient fund to pay the wages of the applicant on the ground of that circular dated 1/7/19, which ensured the switchover of the mode of engagement, and hence after a certain period, as mentioned in the said office order, the respondent authority cannot pay their wages. That's why they are not paid. Said series of waivers were moved on different occasions before the Honorable Tribunal. In the meantime, a committee was constituted by virtue of the court's order. The said committee categorically mentioned the fact that regulation scheme clearly talks about the parameter of the determination of the eligibility, which is sanction post, and the applicants are not working against the sanction post. However, on 28 January 2020, the Honorable Tribunal are pleased to dispose of such way and way 66 of 2020 and 29, giving direction the respondent to constitute a committee directing to examine the claim of the applicant along with the engagement detail and consider that case for regulation strictly in the light of the scheme such and such, and the decision referred to the issuing of appropriate order within 3 months. In view of the direction given to the said order, committee was constituted with the approval of the competent authority by order number such and such to examine the claim of the applicant and with the engagement detail and to grant the personal hearing to the applicant. From 25th May 2020 to 27th May 2020, this committee visited DDK Calcutta, provided personal hearing to the applicant on 26 May 2020 and heard the case of the individual and received the document from the individual applicant. The committee examined the document submitted by the applicant and the document received from DDK Calcutta, keeping in view the eligibility criteria as prescribed, prescribed in regulation scheme such and such. The records were called from the DigiDurasam in respect of their earlier court cases filed by the applicant and related order of various courts order fact related to claim their junior were regularized and the court's order in similar matter. The committee relooked the parameter of the determinate the eligibility applicant under the scheme of 27 August 2019. The parameter of determining of the eligibility of regulation as per Postal Bharati scheme, the cut-off date, only those irregular appointees / engaged who had put in 20 years continuous service against the duly sanctioned post but not under the cover of order of the court of the tribunal as on 10/4/2006. In the examination of document for the purpose of fulfilling the parameter, committee found that only 22 applicants have completed 240 days, but they were not engaged against any specific sanction post during that period. Hence, not found eligible for regulation as per criteria. Applicant eligibility was never examined reference to the recruitment rules of the post at that time. Their initial engagement, as they are not engaged in duly sanctioned post and they are only engaged on purely casual basis for various sundry works. In regard to the allegation, applicant there was junior, they are regularized, whereas the applicant were denied regulation, the respondent were clarified the point that said juniors are regularized in compliance with the court's order dated such and such passed by the Central Administrative Tribunal, both in contempt application such and such filed by the said junior in their favor. Hence, the allegation of discrimination does not stand, covering the aspect and detail. The respondent authority in compliance order dated 28 January 2022 in way number 66677 2020 issued the speaking order dated now challenging this speaking order. This applicant again has come before this honorable tribunal with different relief stating therein. The office order dated 1/7/2019, which talks about the switchover mode of engagement of casual laborer through the HR agency instead of direct engagement through the DDK, Dooradharshan Kendra, Kolkata, and the present dispensation regarding mode of engagement of 33 casual was allowed up to July 31st, July 2019, was challenged on several occasions in several ways. But the Honorable Tribunal did not interfere upon the spirit of this office order, and so long this office order remains operative, the controlling of 33 casual labor through the HR agency continues, and whenever the respondent authority has intimated the applicant that after a certain period of all three laborers should be controlled and managed by the HR agency as per general rules, and on the other hand, their application for regulation conferring the temporary status had not been considered. The respondent authority had no other alternative but to ask them to go through the HR agency. But unfortunately, in this case, applicant, without going through the HR agency, they are again knocking the door of the Honorable Tribunal, knowing it fully well that they are not the employee as per provision of CCA rules. They are merely contact employee. They can agitate before the labor tribunal and not before the administrative tribunal. Now, the reply on merit with regard to the subject. Now, paragraph 9, Milord, that
Don't read the entire pleading. You have read more than enough. You are not here to read the pleading. You should be making your submission, not reading your pleading. This is not the way to assess the court.
that pleading has been taken.
Right, we'll go through it. Don't worry. You sit down. So all of you are still in working there. After
do we have-
2019, have you been working
Yes.
till now?
Not till now.
Then till when did you work?
On 30th of September
30th of September?
this year.
Till then you were all working.
Yes.
Let us see, where have you said that?
No. I did not. I did not. This is my instruction, and I'm just addressing to your lordship.
Let's confine to the records.
Yes.
It appears that after 19, perhaps there is some break.
My lord.
So,
After 19, if I can show your lordship that whether I was working.
yes. Let us see what you have said in your OA.
May I just take your lordship to the order? Because it would be evident from the order also. Please. My lord, will I take your lordship to page number 192 once?
192. What is 192?
192. But that would be a least, my lord. Has your lordship got that?
192.
192. But details of 33 casual working as DDK, that is Doordarshan Kendra. So, my lord, this has been given. Page number 193 is the date. Here, my lord, my name appears.
So therefore, we are saying after 2019. This is of 2019.
Yes, it is October 2019.
So we are saying after 2019, anything to show that you are continuing.
My lord, I can show your lordship because I was continuing. Yes. Hmm?
After 19, it appears that you are only working under orders of the tribunal. As
Yes,
we-
my lord. At page number 156, the order of the learned tribunal is there.
Page?
156.
After 19, it is.
That is the order of the tribe. Because your lordship kindly sees once. One 56. My lord,
What is wrong with the cat's order? Let us see. What
But,
has been, what
do-
has not been considered?
yes, my lord. May I just take your lordship to that?
Yes.
My lord, lordship has seen, my lord, there have been two parts of my prayers. One is regularization. May I take your lordship to the first page of the order impugned? That your lordship will see the first page of the order impugned. My lord, I'm sorry, my lord, the internal page 3. Lordship, the prayers are quoted. Lordship has seen?
Where is the reasoned order of 7/10/22?
Yes. My lord, page number 238.
After 229. Order dated 20.
Has your lordship got that? Page number 238.
238.
Yes. It is 7th of October 2022.
Three pages. 184. 38. Yes.
Yes, my lord, the first page in the impugned order, my lord, the learned tribunal has, my lord, recorded the prayers that have been made in the original applications. So lordship has seen, my lord, the prayers is with respect to, my lord, regularization, and the other prayer is with respect to continuation of them, so that they could be continued. My lord, lordship will kindly seize these ones. C, an order to issue direct, may I please, my lord? An order to issue directing the respondents to allow the applicant to continue as casual workers at present position and posting at Doordarshan Kendra at Kolkata on regular monthly payment of remuneration wages in absence of regularization and or till the completion of the process of regularization and or till the process of regularization, and to grant him all the areas and accrued interest. So, my lord, this particular prayer, my lord, was, my lord, actually took birth, my lord, in the year 2019. So, when, my lord, the respondents issued that particular order impugned by saying that we will be replaced by the agency. That we, I'm sorry,
In 2019?
yes. So 2019, my lord, it's all started.
No, that not in 2019. 2019, you were claiming a temporary status.
Yes, my lord.
That
While it was being
considered-
considered,
That was considered under the orders of the tribunal.
yes.
Thereafter, they said it can't be done.
No, during this interregnum also, my lord, this has
Then
happened.
they came out with a scheme of engaging through agencies.
My lord, that would be in 2019. only.
You assailed that also.
Yes.
That also, as your challenge was not sustained.
My lord,
And,
challenge was, it was directed that it is to be considered by the respondents.
That means not entertain. What they have already taken a policy decision.
Now, my lord, that was the order of the learned tribunal at that time, particular
There
time.
is,
when
even the a fixed monthly payment has not been allowed to you till date. Even that status was not given.
my lord, lordship will kindly appreciate here.
In
But
such
here-
nature of casual employees, what can be done?
But
The
I
law is
was-
very clear.
My lord, the law about the replacement, my lord, lordship, on the earlier occasion, what happened, my lord, here, since there has been, my lord, two perspective of this matter, my lord, two aspect of this matter.
No, the second
the-
aspect is nowhere. You can always go through the agency. Who is stopping you?
No, my lord, we tried that. We tried that, my lord.
They
Also,
take
they
up-
did not.
if
They
they
did not
take
take
an
us.
Then what can be done?
No, my lord, because I tell you, lordship, my lord, this
Having
has
no
been the.
qualification, having no sanctioned post, you have been working for such a long time.
My lord,
That
first,
itself
my lord,
puts you as a privileged class amongst
my lord, first, my
millions
lord,
of others who are still on
my
the
lord,
road.
first, my lord, it is a sanctioned post. Otherwise, my lord, others would not have been
We
regularized.
don't know, that issue is not there anymore to look into.
No, my lord, that subject to correction, but that is that issue is also there before
Scrutiny
your
of
lordship.
these issues have been done. This is not the first time.
Yes.
At least 4 OAs, 2-3 writ petitions, two times matter considered by the Supreme Court. And now you are still stuck in 2019. These applicants,
No,
they have
I-
to know their
But I
position
tell,
now.
I tell you, lordship, my lord, I have
Otherwise
been, my lord, given
will
with the
just
interim
keep on
protection.
continuing like this forever.
No, my lord, may I just respectfully submit? I have been given with the interim protection by the tribunal in this
Correct,
maintenance.
correct. So
Lordship
working
has
under
seen that.
orders of the tribunal and court, you know what
20
benefit that will give you. In a scheme of regularization, when you work under the orders of the tribunal or court, you know whether it will
No,
give you any benefit or it
No,
will
about
not
the
give
not
you.
not about the regularization part,
Yes.
about continuation part
Continuation, if you see,
in 2020.
since you are repeatedly litigating,
Yes, madam.
therefore this you could have quietly continued the way they were continuing.
My lord, I have been, my lord, doing. I had been, my lord, doing this. My lord, what happens here? My lord, lordship will kindly appreciate, my lord. Since I already said, I would not, my lord, reiterate. My lord, since this aspect of continuation that was placed before the learned tribunal also. Now, my lord, sees what the learned tribunal says about that in the order.
Yes. Let us
That
see.
yes, lordship will kindly, because this is my single point now. Because on the earlier occasion when this
What is that? What is the tribunal's consideration?
there is not.
Where is your submission
Yes.
regarding continuation?
My lord, I have already shown to your lordship the prayer,
Yes.
and then if I
So if
request
you
your
don't
lordship,
argue a point, how the tribunal will consider
no,
it?
absolutely, my lord, absolutely.
You may have taken up.
My lord,
there, taken up
if I
may-
request your lordship to see, my lord, straight away, many pages are there where it is small, it is written. But if I just directly take your
Where?
lordship to
Where?
internal page 15
Of
of the order impute.
page 15 of the order. Yes, we are there.
My lord, there your lordship will see 5.6. It says,
No, we are not in 2019 anymore.
my lord.
All those things have been considered at least on 4 occasions prior to this.
Yes.
Now you say during the pendency of these proceedings also you were seeking to continue in your status as you were.
My lord, then in page number 17, the next to the next page, it is considered. It is actually, my lord, recorded.
Page 17.
17, my lord, paragraph number 6.
This is not on that issue. This is on regularization.
No. This is not regulation. My lord, see, Shobhan Shatra is, my lord, mentioned.
This is referring to law. This is nothing. There is no consideration about you.
My lord, this is my prayer where I said that I may not be replaced by
This
this.
is just the recording their stand taken in the rejoinder. The petitioner stand taken
Yes,
in
yes,
the
my lord.
rejoinder.
Apart from this, the tribunal did nothing.
Yes.
So, with deepest respect, my lord, kindly sees that. Apart from this, the tribunal, my lord, thereafter, my lord, went on recording why I should not be regularized, but not with this respect, the submission that I forwarded. This is my grievance before your lordship. Because this subject to correction, my lord, is no more, because lordship is no more, my lord, res integra, that they could not be, even by this agency, this particular agency, they cannot be replaced. Apart from my submissions, my lord, nothing is there in the entire order, subject to correction of my learned senior.
Just see, therefore it is claimed. Just see paragraph 6 that you were
Yes,
reading.
my lord. Paragraph number, page number 17, my lord, para 6.
And
The
why-
applicants have filed the rejoinder, reiterated.
No, therefore we are saying you read, therefore it is claimed by the council that respondents are under an obligation not to disengage them, allow them to continue to work with monetary benefits. This is your claim.
Therefore, the claim that the respondent are under the obligation not to disengage them,
Yes.
to allow to continue work with monetary
benefits.
benefits.
This is your submission recorded.
Yes, my lord.
So then where is
What the learned counsel are relying upon Nihal Singh and Tripura, my lord, where the same point is agitated. Honorable High Court, which I have today. And the respondent ought not to have denied the claim of the applicant for regular now. Would argue that the respondent would not have denied the claim of the applicant regulation as stipulated in the order. According to the applicants are entitled to claim for regularization. That is wrong recording or subject to correction. Neither Tripura nor Shopon Malad with respect to regularization.
they have engaged you only for sundry work intermittently?
No, not
as per
intermediate.
requirement. There
No,
is
not intermediate.
continuity.
They
There
have
are
been
few-
continuously working.
There are
This
few
is
who have shown that they continued for 240 days.
but that,
For them also, it was found in the proceedings, several proceedings.
that is their contention.
That was, no, there is a finding. Finding
Yes, my lord.
duly
But that finding is challenged also before the learned tribunal. That is another aspect.
repeatedly. This is the fourth occasion.
But that was a mistake on their part. Because
Fourth occasion.
but I can satisfy your lordship to that also. That is the second aspect of regularization. When this matter,
The speaking order is very clear.
no, my lord, that part on the earlier occasion, this matter was taken up, my lord. I was trying to assist your lordship. Then my lord senior says that they will be filing up this
we
thing.
have seen, we have
So
seen
with respect to
everything
the second aspect,
Yes.
I was, my lord, beseeching that they cannot
Second
disengage.
aspect, where is your, you said that you have filed a supplementary affidavit in the OA,
My lord,
bringing on record this development that they were trying to bring in someone to replace you.
no, my lord. That was a point for consideration. I showed your lordship, my
Let
lord.
us see the pleading. What have you said?
My lord, the lordship has seen the relief I claimed, which is quoted in the
No, where
tribunal.
is the OA? What is your, what
Very
is
on.
the facts?
Very on.
The present OA.
Yes, man.
Not, don't show us any earlier.
No, my lord.
We
Present
want
way.
to see the OA number 1869.
My lord. That your lordship will be seeing, my lord, from page number 43 it starts. 1869. The relevant part, my lord, I'm taking your lordship. That part only. My lord, page number 11. I'm sorry, internal page number 11. Page 56, running page. And also, my lord, internal page 19. ಚೆನ್ನಾಗಿದೆ. Then, Lordship, internal page 26, your Lordship will see the relief.
We are looking at it.
I'm sorry. But may I just hand up your Lordship, my lord, a list of dates, my lord? I ought to have, my lord, given it to your Lordship, my lord, because there are several dates and facts.
Why didn't you apply through the HR agencies?
My lord, I have been instructed that I tried, my lord, they did not take me.
No, their
Otherwise,
understanding is to the contrary, that you were not interested in coming through them.
my lord, that
You
is
are
what
more
they are-
interested in regularization, and therefore you are trying
That
to
is-
link the two issues to keep the issue of regularization alive.
my lord,
That
that
is
is
what
also
they are
there.
saying.
That is most respectfully submitting, my lord, that is also there. Yes. That is also there.
Yes.
Because that is also, my lord, there. So this is why, my lord, I was relying upon Lordship has seen, my lord, on the earlier date, my lord, I handed up to your Lordship this aspect, because since the I was, my lord, my lord, on the earlier occasion, it is addressed to your
See,
Lordships.
there are two aspects of the matter. They have
Yes, it
gone
does.
through a procedure for regularization. Some have been regularized. There, we don't know how many posts there are as of now after regularization. Whether there are two, whether there are 20 or 200, we don't know.
My lord.
So now it will only, if they have any work, you can continue. Otherwise, you
But
cannot
this-
impose yourself on them merely because you have been working on sundry work as a casual, knowing your status very well for the last 20, 30 years.
My lord, this part, my lord, I can satisfy your Lordship about their observation in the order impugned. Impugned before the landed tribunal. Their observation is factually incorrect. That I can show your Lordship to them.
No, we are not going to go into facts. That's not the scope.
About the, because earlier date, my lord, when it is said that about the regularization part, they will be using, my lord, affidavit. So I said that about this second part, at least, my lord, this benefit to be given, my lord, till they give
Everything is
this.
clear. All the material is here.
Yes, my lord, that is there. That is there. If your Lordship, my lord, wants, my lord, me to, my lord, argue on the part of regularization, otherwise, my lord, I was ready, made myself ready, my lord, with respect to the second aspect.
Yes, you address us on the second aspect.
Grateful,
Yes.
my lord, this part, my lord, I was just taking your Lordship to, my lord, they said that this particular scheme, my lord, which, my lord, they floated in, which they said about 2019 was of 2012. My lord, may I request your Lordship to see the scheme once in 2012? Page number 283, my lord.
2012 is over.
No. What I was saying,
Long back.
they take this point that
They
it
are
is
not taking this point. They are relying upon the latest HR policy.
yes,
Which
that
says you go through the GEMS portal, you hire an HR agency.
my lord, that
For
my
such sundry work, don't keep anyone there.
grateful. My lord, that part, my lord, is already decided by this honorable court, by the honorable coordinate bench, whether this could be done. Lordship will kindly see that I have handed up to your Lordship on the earlier date. My lord, the
But you
judgment,
have to challenge that for getting such an order.
I have already
It
done
cannot
that.
be done collaterally in this way. You have to challenge that scheme. That scheme is not under challenge before us. How
But,
do we interfere with the scheme?
No, it's not about the scheme, my lord, about the continuation.
No, it is surely about the scheme.
But
They
because-
have a policy now. They have come out with a policy which appears to us to be quite a reasonable policy because they have gone through two exercises. One, the Prasar Bharati regularization scheme. They were conscious that they are hiring people like this because Doordarshan was a new venture. It was spreading throughout the country. They did it. Now, having done so, they took an exercise, weeding
Yes.
out. It may be a weeding out.
My lord,
All those who were against sanction post, all those who were duly qualified,
Lordship.
applying the principles of Secretary of State of Karnataka judgment.
Yes.
So they undertook that exercise. Some of you who were originally were part of your group, they also benefited from that. Some have not benefited. That is an exercise which is. The second aspect is that now that they have regularized,
No.
their department says that now the vacancies, only these vacancies exist. You do it through an HR agency. Why should you be hiring people on a direct basis?
My lord,
Very reasonable approach.
my lord, this part, my lord, this would not be, my lord, subject. Your lordship kindly sees this, because whether this would be permitted, because this particular
So
action,
therefore, whether it is permitted or not has to be directly challenged.
or that is
It
challenged.
cannot be, it's not challenged.
Lordship kindly sees this once. Once I take
You
your lordship.
have not challenged the HR policy.
No, my lordship kindly take this, my
You
lord.
only
once.
say they should allow me to continue. How can they when they have a policy?
My lord, page
And
number,
when you don't challenge the policy.
my lord, page number 206, my lord, says it is
Yes.
the order of the learned tribunal on the earlier date.
Earlier all orders have now merged in this 710 speaking order.
Yes.
Prior to that, you have got nothing. You have only got a continuance by virtue of some orders passed intermittently in the 4 OAs. And that is why perhaps you are there till now.
No, my lord. The
Otherwise,
interim order
you would
was
have been gone long back.
subject to correction, my lord. The
No,
interim
we have
was
seen the orders.
no. First order of interim measure, my lord, I got in 2020, not before that. I
So
was
therefore, at least for the last 4 years, you are only by virtue of an order, they are giving you some work, whatever they have, they can take from you. That also is not even on a fixed monthly remuneration also you don't have. So it is quite obvious that it is a everyday kind of a thing, intermittently, casual, seasonal, whatever you call it.
So whenever, my lord, they first, my lord, took this point about ourselves being replaced by an agency in 2019. My lord, that point was challenged before the
Yes.
learned tribunal. The tribunal says that you consider, make a fresh representation and consider. We do that, then they come up and say,
Policy can be considered by way of representation.
my lord,
We have seen the orders, therefore we are telling you, you can't do it like this shadow boxing. If you had to challenge it, you have to challenge it.
my lord,
You are not without challenging, how can you continue?
my lord, I tell your lordship,
claim
the-
any relief
it
to the contrary?
it is not the scheme.
You cannot direct them to do anything contrary to their policy.
My lord, it is not with the scheme. It is, my lord, the office memorandum which is challenged. Now, this office memorandum, when we challenge, the tribunal
Not
say,
in these proceedings.
no,
Nothing here in these.
no. How this came, my lord? If I am permitted, my lord, if I
We
could
will not
satisfy
allow
you.
you to reopen those issues.
No,
which
my
have
lord. I
already
tell your
concluded.
lordship, when they said that this is the office memorandum that you would be replaced by the agency, I challenge. Tribunal say make representation, so that you can be
Make
permitted to join.
representation, not challenging the scheme. Make representation allowing you to continue.
My lord, so that you can be
That
allowed to
issue
be
was
continued.
not decided. No, you did not take
But
it up.
No, then they, my lord,
You
pass
are
this.
not interested in assailing the scheme. You are interested only in somehow staying there.
My lord,
Otherwise, you would have taken it up. You have never done
my
it.
lord,
You are keeping it
if I-
in the
if I- if I-
sideline for raising it as an issue collateral to your claim for
if
regularization
I take your
in
lordship,
every proceeding.
have been only agreed by the office memorandum, because I am basically not agreed by the policy. That is my contention. I am not agree,
Cannot be. The OM is in terms of the policy.
No.
Cannot be.
because this policy is not applicable to that OM. This is why I was taking your lordship to the policy once.
When that policy is not before us, that's
no.
not before the tribunal, that is not before us.
No, it was there before the tribunal. It was annexed also.
Let us see in your prayer anything about the policy.
My lord, I tell your lordship, it is because I did not challenge. Do not want to challenge.
Therefore, we are not going to look.
No. My lordship will kindly hear me for a moment.
Yes.
I'm sorry, my lord, I'm bothering your lordship, my lord.
No, you're not bothering us. You
But,
are trying to take us somewhere where we are not willing to go.
I
And
tell your
for a
lordship,
very specific reason, we have made very clear. Issue
Now-
which was there, you take us, we will see everything. Don't try to take us into the history of the 4 A's,
I will
OAs
not.
which stand concluded.
I will not, because I will get myself confused with that.
We
I
will
will not do
go
that.
into that.
No,
Whether
I just tell
confusing
your
or not,
lordship, my
that's
lord,
a different thing.
because it has, my lord, fallen from your lordships that
Yes.
why since I did not challenge the policy, then I cannot take this point
We
right.
cannot, we
Yes.
will not allow you even if
May
you
I-
submit.
May I, my lord, answer to that only?
Yes.
My lord, I am not agreed by the policy. This is why I did not challenge it.
But the impugned order, speaking order takes into consideration the policy.
Wrong implemented the policy. Wrongly implemented. This is why I impugned the order I challenged.
All right.
This is why, my lord, I was requesting a lordship to see the policy once.
No,
Only
no,
one
sir.
line.
Come to the impugned order. Come to the impugned speaking order.
Yes, my lord. my lord, which your lordship will find at page 238. জায়গাটায় তো মিসটা আছে না? এটা ধরেছে।
And this is in response to your representation, which was filed only for regularization. This order is passed on a representation filed only for regularization,
But if I
nothing else.
But
Let us see.
lordship kindly sees
Yes,
my representation then.
yes, where is it?
But
Third line.
page number 162, my lord, one representation is annexed.
We are not going to see you. You see the order of the cat quoted at page 1 of the speaking order.
Yes, man. Yes, yes.
Yes. Nothing more than regularization.
Yes, my lord.
Yes, nothing more.
My lord, this is the mistake that they have done. Because I have been, my lord, making.
Could have challenged the tribunal's order instead of complying with it.
My lord, this is the mistake, my lord, that they have done.
You
So
should
this
have
is why I
challenged
challenge.
the tribunal's order instead of complying with it and filing a representation. You asked for a particular relief, the tribunal gave you the relief, you availed the relief.
No, my lord.
Now you can't say it was wrong or it was.
Lordship is talking about the tribunal's order.
Yes.
Lordship, I follow.
The tribunal, you got
that-
an order that we are to be considered for regularization. That is the only order you got.
My
There is
lord,
no question of getting an order because you know the policy is in existence or being wrongly applied since 2019. Still in this order,
my
there
lord,
is
I
nothing.
challenge that, my lord, ordered of the policy.
There is nothing in this order of the tribunal.
But this
that is a
particular
cla-
order, yes.
That claim is not there. It's gone.
My lord, the tribunal, my lord, did not. What happens, my lord, lordship has also seen, my lord, the instant original application. In spite of making this application, in spite of recording my submission, the tribunal do not go into the merit.
We are not on that. You
But,
cannot
because-
reopen something which you have concluded in OA 677 of 2020 filed by you. 677 2022 confines your relief to regularization quoted in the speaking order. This was the scope of the scrutiny to be done by the authorities, which they have done. Now we will not allow you to introduce something new
My lord, kindly appreciate here, my lord.
because it's not something new. It is something which we may say you have abandoned. Otherwise, you would have taken it up in OA 677 of 2020 also. It was very much in existence much prior thereto.
My lord, I have taken this. If I request your lordship only to see, my lord, one order of the learned tribunal. What happens here, my lord? May I respectfully submit, my lord, since there have been two claims altogether.
No, there is one claim.
No,
OA number
the
677.
tribunal says to consider. They do not talk about that particular part.
The tribunal does not say to consider
The
your
previous matter,
continuance.
in the previous.
The tribunal only gives you a relief which you ask for.
My lord, I
considering
follow
you
your
for
lordship. I
regularization.
follow your lordship because on that particular tribunal's order, my lord, I was not agree because at that time I was, my lord, also working.
Well, you knew you
And-
had already assailed the policy which was trying to replace you. You knew that you are continuing
No,
in spite of existence of such a policy.
my lord, policy
It
is
was-
not against me,
All right, the OM was already there. OM of 2019.
which I challenged in the original application.
It's not challenged here, sir. There is
Here,
no,
not
no
here.
relief, no relief of
No,
that.
not here, my lord. On the earlier original application, in which the direction was
We are
for
running in
representation
circles.
consideration.
Now we are running in circles. See, in 677 2020, you had the option of taking up the issue of OM of 2019.
I completely follow what is
Have
calling
not
from.
taken it up. You have only enforced your claim for regularization.
Yes.
This can't be a oscillating kind of a fishing in, fishing for relief. Sometimes doing this, sometimes doing that. There is a pattern of litigation now going through 4 OAs. In the meantime, you have taken up the scheme of 2019. Thereafter, you have not taken it up. You have thereafter taken an order only considering your claim for regularization. So now where is the occasion? They have considered it. And that was the subject matter of the present way.
Absolutely.
Now you want to reopen something of 2019 which you have abandoned in the earlier proceeding.
But
Whether that could be done or it could be looked
Malad,
into.
may I answer to that? Try to answer to this, Malad,
Yes.
because what has fallen from your lordship is absolutely right.
Yes.
But my lord, there has been, my lord, a situation that is created by the learned tribunal and also by us and also by the
you.
authority.
By you.
No, I tell your lordship,
Can't
why
say
not
the
only by
tribunal has created it. You have taken up the order of the
I
tribunal
tell your
before
lordship-
the High Court. You have taken up the order of the High Court before the Supreme Court on an earlier
No,
occasion.
no, that is with respect to
So you,
regularization.
so you could have done it here also. Don't say it is a creation of the
No,
tribunal.
no, I tell your lordship what happens here. My lord, that your lordship has seen the Honorable Supreme Court, that is with respect to regularization. Not regularization, but
We
the
are
temporary
not on
status.
that. We are saying
Not on that. Not on that.
wherever you have wanted to take up the issue, you have taken it up. So
Yes.
obviously, you didn't want to take that issue up. Otherwise, you would have taken it up.
My lord, why, my lord, this has happened? Because
Whether it now it can be looked into.
But,
Forget about the reason.
this reason, my lord, in that event, my lord, my straightforward answer to your lordship is that the tribunal ought to have rejected on that spot.
Yes.
Lordship
Not
kindly-
required. Not required.
My lord, they will not even, my lord, discuss this in the order impute
Sir,
before this honorable court.
your order speaking, your entire claim was merged into the order passed in OA 677 of 2020. That is the direction. Now, henceforward, this is the confines within which your claim has to be examined.
But in my
And
original application, I take this point.
You
In,
may,
in my submission, I take this point. It is recorded. Then the tribunal thinks, my lord, will not discuss about this.
Yes.
This, my lord, I am definitely aggrieved of.
All right. So we'll consider that.
Kindly appreciate that, my lord, because which will be, my lord, leading me to a situation, my lord, that I will not be able to.
There has to be no finality to any decision.
My lord,
Whenever the applicant or petitioners feels like in a series of 6 litigations, they will take up whichever issue they want. We'll deal with this aspect. We'll consider this aspect.
I know that, madam.
We'll consider this aspect.
Lordship would kindly appreciate only one thing here.
Finality of see, you have to realize where you stand.
My lord, here lordship will kindly appreciate what the problem, what I was just trying to, my lord, assist your lordship to what problem has happened.
Yes.
Problem happened, my lord. I previously made only, my lord, 1 minute of your lordship's time.
Yes. Please tell us.
Problem happened, my lord. Initially, it was with respect to regularization and also, my lord, with respect to the let us be continued.
Yes.
Then, my lord, the tribunal, my lord, the tribunal asks us that you just make the representation and thereafter it would be considered. Representation made, and after consideration, the result came, no, it will not be regularized. I accordingly, my lord, challenge that order of not being regularized. Since that other aspect of this,
Not that simple. You have already challenged OM of 19.
my lord,
You have challenged it in a duly constituted proceeding before the CAT. You have not succeeded.
I was directed to be making
You
a
have not
representation.
succeeded. Knowing that you have not succeeded, you have proceeded in that
Lordship
way.
will kindly see the order of the
We
tribunal.
have seen it. That's why we are saying they
But
were asked to make a representation. Where is the question of representation against an OM?
My lord, they also did not challenge that order.
Why should they?
Because, my lord,
Their OM was sustained
But,
without interfering with the OM. They said that you consider whether they can be continued or not. So there's no occasion for them to challenge.
I follow, my lord. If the tribe, I challenge a particular office memorandum before a court of law. The court of law says that you are permitted to make a representation against that particular office memorandum.
Where is that? Show us against the make a representation against the OM. Just show us that in
Yes,
the
ma'am.
order.
Lord, you kindly seize that one.
Yes.
My lord, 205 is the office memorandum.
Just show us where they have said to make a representation against the OM.
Yes.
Where the tribunal
My
has
lord,
said.
206 kindly seize.
Page
206.
Page 206.
206.
That is in OA number.
I tell you, Lord. My lord, that would be OA number 1675. 2019.
Just a minute, let us find.
I'm sorry.
(206) is order of 23/12/19.
Lordship.
Yes, where does it say to challenge the representation challenging the OM?
but it says that at hearing, it would submit the applicants have failed to produce document that they are required for appropriate consideration in the case terms of policy of the department in vogue.
Yes.
And then learned applicants contradicts the same. Learned counsel applicants further assures that all the documents that are required to be furnished at the applicants be furnished at the time of the 1 week. Yeah, should be to be later. The previous order, previous page, which is my challenge.
Only for regularization. This
It
is
was
only for
if I can show your lordship the original application,
there
I
can
can
be no such order that you file a representation against the OM. Therefore, we are
if I-
asking you to show us any such
if
order.
I can
There
be
can
permitted
be no
to
such
produce
order.
the copy of this original application.
No, not required. The order is here. We don't require to see that. You said that you were directed to make a representation against the OM. We were wondering how such an order has been passed. So we wanted to see whether the tribunal has passed such an order.
Very well, my lord. Kindly take the trouble once more, my lord, in 202.
This is in the same proceeding or earlier proceeding.
In an earlier proceeding.
No, that 19 now don't take us to.
No, my lord, that is the one which I challenged, the office memorandum.
Therefore, we say after that you have not done anything.
Because after that we are permitted to make the representation, seize, my lord, the order, which I was, my lord, trying to assist you.
In this also shows that they have asked you to make a representation against the OM. Let us see whether they have said.
Is that page number 202. I can show your lordship that.
Let us see.
My lord, here, my lord, the challenge was 1719, 111119, my lord, sees. Directing is then, my lord, C is the regularization.
Yes.
A, B is different and C is regularization. Divided joint prosecution since traverse a long checkered. Respondent issued office order. Casual. My lord, internal page number 6, that is 203, running page, top. On 1st of July, respondent of 5 had issued office order that the casual laborers would be engaged through outsourced agencies, being aggrieved, moved tribunal, which was disposed of by the tribunal with the liberty of the applicants to prefer comprehensive representation, citing rules and judicial decision in their support, and the respondent authority directed to dispose of the same, specified time frame with the law. Respondent authority issued a speaking order on such and such, being agreed by which the applicants had approached the tribunal in this present way.
Now just see how you have abandoned this claim. Just read further.
During hearing, counsel would avert that the respondent authority in the meanwhile have published. In the meanwhile,
Now, they have issued a speaking order with respect to that office memorandum that you challenged on 11/11/19.
lordship.
Are you now you are not bothered with that?
No,
Now
my
you
lord,
say
being agreed by that, I came before the tribunal.
no. You came, but then look what you have
Then, my
said.
lord, sees what happens.
Then you say that the
During
applicants
hearing,
that they in the meanwhile they have published a
scheme for regularization.
Now
Or-
we are interested in regularization.
That's preferred the representation, praying for regularization.
Regularization. So therefore, the issue of 11/11/19 speaking order is gone.
My lord, then, my lord,
Neither
comes down.
raised nor considered.
My lord, kindly comes down. My lord.
11/11/19 is the speaking order dealing
Yes.
with your representation against the OM.
Yes. Yes, my lord.
Yes.
Then, my lord comes down. My lordship has seen the next paragraph. During hearing, the scheme came.
Yes.
Learned counsel applicant was hence urged the applicants would be fairly satisfied if a direction be issued to dispose of such representation in a time-bound manner.
For regulation, yes.
Learned counsel for the respondent, per contra, would contend that the respondent issued speaking order on such and such that complete representation are yet to be received by the respondent in response of the scheme dated 22nd
Regularized.
August
Now all regularized.
2019. Respondents, however, does not object consideration of comprehensive representation. Accordingly,
Nothing about
entering into the merit, we hereby direct to address such representation to examine representation in response to their scheme if received at this end. My lord, this is where, my lord, things lost track. This is where, my lord, I was trying to take your
Consciously
lord.
you have submitted that now the scheme has come. Let us go for that.
My lord, subject to your lordship correction, my lord. My lord, these incumbents, my lord, have been working since long. My lord, they have been, my lord, praying that they could have been regularized like their other colleagues.
Yes.
Then, my lord,
So after this, there is nothing on this 11/11/19 or OM of
thereafter, my lord, it went.
nothing.
Thereafter,
Now
my
all
lord,
of a
it went.
sudden, 2 OAs later, in this case, you say that allow me to continue.
Because, my lord, because that particular issue was not
So
finally
that-
decided.
So the challenge to the policy is over.
Policy, I did not challenge. The OM.
No, you challenged.
No, policy I did
The
not.
OM you challenged,
OM I
implementing the policy. The OM you challenged, the court considered, they said pass a order, they passed an order. That order you brought on record, but you said we are interested in regulation. Therefore, now your claim for
Now, my lord,
regulation.
this is where, my lord, the things got lost track. Now, my lord, kindly appreciate, my lord, the incumbent situation here. My lord, they have been, my lord, working, they have been praying for regularization, and at least they so that they could be, my lord, continue with that. That was the perspective of the entire matter. Now, my lord, what happens? In this meantime, they framed the policy. I was considered rejected. I once again challenged that. And my lord, I reiterated the claim that as per the policy itself, you cannot take me out because the policy does not ask you to take me out. Because, my lord, the law always, my lord, remains as it is, my lord, given by the statutory authority. The statutory authority says anyone who is engaged after 2012 will be replaced by the agency.
Yes.
But we are someone, my lord, who are engaged in 1992. So this is why the policy is not applicable on us. This is why
it's not an issue before us.
My lord, this was the issue before the learned tribunal, my lord. Lordship would kindly appreciate that.
There is no issue of the policy before the tribunal.
My lord, because that was the prayer. My lord has seen that.
There is no issue regarding the policy in the prayer, even in the prayer.
My lord,
only a direction to allow you to continue.
Because there is no policy standing in the way.
You know that there is a policy. Now again you are running in circles.
My lord, what, my lord? Because I was desperate in, my lord, keeping my livelihood, my lord, alive. So, my lord,
that we appreciate. That is, of course, that we can appreciate.
This is exactly my point and nothing else.
Like to continue, but then this
is
not
only
the way,
thing, my lord, I am praying today, my lord.
Not the way by resorting to litigation after litigation to somehow stay in.
My lord,
we'll have to consider whether it can be appreciated or not.
My lord, Lordship has already observed. Yes. It has already fallen from my lords that these litigations are with respect to the regularization in this meantime, and because I was continuing in that particular time. So now, my lord, now they are, my lord, taking away my right also for regularization in one hand, also, my lord, taking away my
Nobody has a right to regularization. Nobody has a right to regularization. Forget about your right. You have no right to regularization.
No, I ought not have used the word right.
Yes.
So, my lord, I ought to have,
you could have been
my case was to be considered for regularization, and also, my lord, my prayer so that I may be continued with the livelihood, so that I can have my livelihood, since, my lord, I have been working in 1992 during this interregnum, my lord, also, my lord, and be that as it may.
There is no
Thereafter, my lord, what happens now, my lord? They say that irrespective of the policy may not be applicable to you. Irrespective of the policy, you will be replaced by the agency. But this practice, my lord, is deprecated by this honorable court, by your lordships. Kindly, my lord, sees that part.
That is not an issue here, sir. Sorry, we
My
are
lord,
not
that is
going
with
to
respect.
enlarge the scope of the OA. We are not going to enlarge the scope of the OA as hard as you may try. We will not do it. You have made a simple prayer for being allowed to continue.
That is it.
There is no issue regarding the policy raised by you. So we are not going to venture into
I will
that
not. I will not take your lordship with the policy. No, my lord. I'll just leave my effort to that.
If you want to continue,
that is only my prayer now.
You can.
That is only my prayer now, and the
Otherwise,
judgment.
are you willing to? You have any work that you can take from them? Without any measure of permanence, without any claim for regularization. If you have some work, then we want to resolve this issue in this matter. They will also give a given writing that yes, we are willing to work as per availability of work. If they are willing to do that, we can ask you to continue till such time the work exists.
And that was the prayer made in the this original application.
No claim for regularization.
That was the prayer, my lord, in
No
the
claim for regularization. You take an instruction only whether any nature of work is existing, and as and when work is required, you will give them preference. That is all that we can do. Nothing more than that.
About the preference part.
But be very conscious. We are asking them on a presumption
that I will not pray for regularization anymore.
You will not claim any right.
I'll also take my instruction.
This issue has to come to an end. It cannot go on litigation after litigation. This is the 5th round. There has to be a limit.
Want to continue?
Yes.
As per available work. As per available work.
I shall.
With no right accruing in their favor otherwise. Because if they continue in terms of the order of the court as it is, they will not be allowed to take any benefit of this. Just come back with the instruction. We are not recording any order. We also expect that you ask him. They may not be willing. We don't know.
No, my lord, I'll ask. I think, my lord, they will be willing.
We don't know
Because
seeing the way they have been pursuing.
But since the matter is almost over, since the matter is almost over, my lord. No, very well, very well. I will not mind, my lord, giving undertaking, my lord. Since the matter is already over, my lord.
Because of the air document of this particular loss of livelihood happened.
See, we have.
So this is why I am not. This is not a submission that I am making. And our situation. But this answer is the previous order of my lords. Kindly seize my lord's previous recording. Yes, this is the answer will be that only that. Only on that we are relying and nothing else. I'll And if also, my lord, the department would have, my lord, followed the procedure established by the Honorable Supreme Court in Nuadevis, my lord, they would have been at this particular time would have been regularized by now, because they were of from 1992. I'm not taking this point anymore, my lord, because I already asked your lordship. But if they can, my lord, grateful, my lord, because this I'm sure, my lord, I'll be. Yes. I am sure. I'm sure, my lord, they will be also, my lord. I'll be talking to them, and I'm sure, my lord, they will be, my lord, willing to give the undertaking also. I think, my lord, they will.
Take down Heartland Council for the party. Why? 13 December. The other matters are not analogous. Are you representing everyone?
Yes, ma'am. Oh, Calcutta.
Yes, I think
Like last order, same order.
I'm sorry, man. তো এটা এন্ট্রি করবে ও আচ্ছা তাহলে অসুবিধা But I'm so grateful to your lordships, my lord, for giving us, my lord, my lord. And in spite of the fact that you have been repeating my submission. perhaps, my lord, that will be beneficial for them also. Because going on with the litigation also, my lord, gives. Grateful.
To have the copy of a brief.
Next item,
But I'm for the petition.
what do you want?
Not today, Malan, the next week, so that I can go through it.
You're filing something.
No, no, man.
They're already enjoying an interim order, man.
No, what do you want to file?
Not today, nothing, Malan.
But he's saying that the next matter, but he's praying for time.
So you want us to take it up?
No,
Yeah, obviously you want us to take it.
But kindly see, my lord, there is an order 21st of November.
Yes.
But I'll be praying for, my lord, limited extension of the same.
No, where is the next? Call the next matter, 25.
Malan. No, nothing, man. Only yesterday I got the brief. I never got the chance to go through it, but I
Learned counsel.
Item number 26.
Lord, I am appearing on behalf of respondent number 1 to 5.
My lord, I beg to appear on behalf of the petitioners. My lord, on the last occasion, my lord was pleased to direct me to serve a copy of the order dated 4th November 2024 upon the learned advocate appearing for the respondent, Kendriya Vidyalaya Sanghathon. And I have also served the, as per your lordship's order, on the respondents, answering respondents. Yes, yes, my lord. But this is the affidavit of service pursuant to your lordship's direction. If my lord may kindly recollect, my lord, on the last occasion, I have extensively placed before your lordship the order of the disciplinary authority as well as the order of the appellate authority, which is a non-speaking order. My lord, the five. My lord, I tender unqualified apology. My lord, I have prepared only one copy of the affidavit service. I will get it Xerox and I will serve. Yes, my lord. Yes, your lordship has pointed out. No. That's true, my lord. Your lordship has pointed out. Your lordship correctly recollects, my lord. My submission was twofold on this issue that, my lord, the principle. Yes, my lord. Kindly comes to the order of the disciplinary authority, which is at page 203, capital A. My lord.
Just please see the order 203A. Devoid of any reasons whatsoever.
And the appellate authority has only reiterated the finding by the disciplinary authority without assigning any reasons been made out, and
no fresh ground has been made out.
No fresh ground has been made.
That is what he has said.
Yes.
If we remember correctly.
Yes, my lord.
Where is that order?
My lord, that was, my lord, only two things I have pointed out to your lordship. My lord,
Where is the order of the appellate authority?
My lord, may kindly comes to the order of the appellate, page 207, 208. 207, it starts. What are the?
Yes.
The charge sheet was issued on twofold grounds. That abusive language I have used against the principal, who is the who has not been adduced as an evidence before the disciplinary authority. Secondly, my lord, I have started half an hour late for the purpose of holding examination in class 4, section A, so far as social studies paper is concerned. On the twofold grounds, my lord, the several additional documents I have sought for and some additional and some witnesses I propose to adduce in evidence before the disciplinary authority, which the disciplinary authority, in spite of there being specific rule to that effect, my lord, has not permitted me to adduce the oral evidences. But so far as the additional document is concerned, what has fallen from your lordship, my lord, that I have not assigned any reasons for calling for those documents before the disciplinary authority concerned. And but so far as the adducing of the evidence, defense witnesses, my lord, these kindly see the, my lord, the rules once. CCS rules, rule 14. Kindly come to rule 17 once.
Yes.
Rule 14, sub rule 17. My lord, rule 15 relates to the prosecution witnesses. May I place 15 once? If it shall appear necessary before the close of the case on behalf of the disciplinary authority, the inquiring authority may, in its discretion, allow the presenting officer to produce evidence not included in the list given to the government servant, or may call for new evidence or call and re-examine any witness, and in such case
the government servant shall be entitled to have, if he demands, a copy of the list of the further evidence proposed to be produced and an adjournment on the inquiry for 3 clear days before the production of such new evidence, exclusive of the day of the adjournment and the day on which the inquiry is adjourned. The inquiry authority shall give the government servant an opportunity to inspect such documents before they are taken on record. The inquiring authority may also allow the government servant to produce new evidence if it is of the opinion that the production of such evidence is necessary in the interest of justice. Note, new evidence shall not be permitted or called for on any witness to be recalled to fill up any gap in the evidence.
Why are you reading this?
Is-
What is
and
the point?
Kindly come to 17.
What is the point? Tell us.
So far as the prosecution, the benefit the prosecution evidence gets at the time of adducing evidence, the similar opportunity must be given to the
Where is the
delinquent.
question of any evidence. Yes, just come to the order, page 203A. Where is the reason? We are asking you. Please come to page 203A. Where is the reason in the order? Where is the consideration? And whereas after careful consideration of the record, what consideration? Which deposition? What is the inquiry report? Nothing. You do not regard the findings and also taking into account the fact that the undersigned is satisfied. It's nothing. And the same thing appellate authority has done. He has taken note. See, you please come to page 207. 207. He has taken note of the submissions, small Roman 1, 2, 3. And whereas the undersigned being the appellate authority has observed. This is the order. That's it. Does not manifest any consideration, any reason in support of the order whatsoever. The report, inquiry report was against you or in your favor?
The inquiry against me.
Against you. So you must have submitted a second show cause.
Submitted representation in persons thereof. But this was to be discussed.
This has to be discussed.
Yes.
Where is the second, where is his representation?
That is also.
Page 193.
That opportunity was also given to him.
No, I'm just trying to see whether he has elaborated. Yes, it is. It is quite a, he has raised many issues. It was required to be considered. Can you please show us the charge memo?
Pardon me, Lord?
Can you please show us the charge memo?
Charge me.
That's it is there.
Page 98. Page 99 is the article of charges.
What is PRT?
PRT is a primary teacher.
Primary teacher.
Primary teacher.
Yes, please take down. Third Land Council for the Affidavit of service, take it on. Affidavit of service. The writ petition is allowed. Writ petition is allowed in the above terms.
Item number 27.
I appear in this matter for the respondents.
But I am present.
Last occasion, your lordship took up this matter when the affidavit, copy of affidavit in opposition was not served upon my learned friend. That's why matter stood adjourned. Now, Lord, copy has been served on the same date. The thing is, this Lord, this is the matter pertaining to landlord's appointment. Now, Lord, 8 petitioners are before your lordship. Lord, 8. The 2 have been given appointment.
2 have been given.
2 have been given appointment.
Which are those 2 persons? So for 2 of the petitioners, it has become infructuous.
That's
Yes. 4. Item number 4.
আমি সবগুলো একটু বলে দিই তারপর দাদা একটু বলবেন হ্যাঁ আমি বলি Lord, appointed petition number 4, appointed petition number 6.
Any dispute on this?
No.
So we can record insofar as 4 and 6 is.
Lord, the other 6 petitioners, Lord,
Yes, insofar as petitioners number 4 give the petition insofar as these 2 petitioners is concerned is dismissed as infructuous.
In respect of the other 6 petitioners, I give your lordship the status. The petitioner number 1, Lord, he did not qualify in the physical efficiency test. 1. PET failed. PET failed. 2 is also PET failed. Lord, 3 non-metric plus overage it.
Yes.
Now, Lord, 5 PET failed. Lord, 7 overage. 8 is also overaged.
Yes.
So this is the status. Now, Lord, your lordship query was this: that in terms of why they were disqualified in the PET or disqualified in respect of age. That was specific query by your lordship on the other day. Because Lord, your lordship stated in our affidavit in opposition that certain developments took place because so many matters were pending before the learned tribunal in respect of claim of land losers appointment.
So this is by virtue of acquisition in which year?
But this is just
Acquisition of which year?
10.
2010.
Acquisition 2010.
Yes, sir.
And the scheme is what dated?
The scheme is 16 July 2010.
16 July 10.
10.
Must be a pre-existing 16.
একটা কপি যে আরেকটা কপি লাগানো আছে এটা কপি করে হ্যাঁ
এটা কোন ম্যাটার বলছো?
হয় So many appointment was made in this circular. We are,
Yes. No, but I just give your lordships the facts. But if your lordship takes, but this writ application arises out of dismissal of a or disposal of a contempt petition by the learned tribunal. Now, my lord, the learned tribunal was satisfied that there was no contempt. For the delay, my lord, we tendered unconditional apology and the contempt petition was disposed of. Now, my lord, against the order of the contempt, this writ petition has been preferred.
yes. On page 85, there is the parent order.
85.
Yes.
Can you please place it?
Parent order.
Para 10.
Yes. Directed to give appointment within.
Please place it.
Lordship, may I? In view of the direction of the Honorable High Court and our revelations as indicated above, we feel it appropriate in the interest of justice to direct the respondents to undertake an identical exercise as directed by the Honorable High Court in WPCT number 74 of 2016 and issue appropriate order in regard to the present applications within 4 months. Accordingly, along with the present OA, all the OAs cited above that related to identically circumstanced land losers in regard to the same project as in this OA or otherwise whose right to employment under land loser category flows from RB 99 of 2010 are disposed of with identical direction pending MS in the same of the OAs also stand disposal.
Therefore, so many persons have been given appointment. We have also annexed it. Thereafter, when they have not given appointment to us, not us, so many persons, everybody has filed a contempt. In this contempt application,
Yes.
thereafter we have filed a contempt. That contempt application has disposed of unconditional apology for delay. No order was passed. We have challenged it. Now, so many order passed in the coordinate bench. Some person have been given appointment for that. And we are not.
Where is the order rejecting your claim?
Well, there is a page 42, 43, last page.
Those orders you have not challenged?
Yes, I've challenged.
Where?
Well, contempt application there. Contempt application not been accepted.
No, whether you have challenged the order whereby your claim was rejected.
Yes.
Where is it?
Well, this is the last annexure. They are.
After the CAT directed them to consider.
Challenge here.
Where is, in which proceeding?
This proceeding is arguing before your.
How can you challenge in a contempt proceeding?
That is can we see the order?
We are asking you whether you have challenged it. We are not asking you whether you have filed a contempt. Those orders, if they are not to your liking, you are required to challenge those orders.
In this writ petition, I have challenged.
You cannot. In a contempt proceeding, how can you challenge the order? You cannot. It is only to see whether the order has been complied. That is all. It can't be enlarged beyond that. You are aware of the law in this. But we know.
That so many petitions have been moved in this court.
That we are not asking how many, we are asking whether.
So many orders have been passed by this court on
Yes.
this petition.
Yes.
Your lordship kindly see this is the order.
No, let us confine to the facts of this case. So what is the contempt? Show us what is the contempt.
Contempt is, Milord, not comply the order of the tribunal, which order was passed within 4.
So what aspect has not been complied? Let us see. Which part of the order has not been complied?
My lord. Just now I have read number 85. Direction was given that given appointment within 4 months.
No. Where is the direction to give an appointment?
Can you see?
Where is the direction to
Prior
give
to
an
that 74, WPCT 74 of 16.
We are not listening to 70. We are asking where is the direction to give an appointment? Show us.
In view of the direction of the Honorable High Court.
Yes.
And our report. Kindly see to it. And our
revelations as indicated above, we feel it appropriate in the interest of justice to direct the respondents to undertake an identical exercise as directed by the Honorable High Court in WPCT number 74 of 2016 and issue appropriate order in regard to the present applications within 4 months.
Yes. There's no direction to give an appointment.
That 74, WPCT 74, you got the 74. But I'm reading the order.
So that is also an order passed in contempt.
Yes, Milord. This contempt.
No. The CAT has directed to pass orders
in this contempt. So many petitioner order was this. Prior to that, Milord, so many petition was moved before this court challenging that rejection of contempt. For that reason, the order was passed. Your lordship will find page 15 in my petition. That is another order was passed.
No, where is the order of rejection?
Page 15.
Rejection order.
Rejection order, that last order in the contempt.
No, rejection by the authorities.
Authorities did not take any steps. Did not reject.
They have not passed any order.
Any order. Therefore, Milord, this order was passed. They did not take any steps for that from 2010 to 2024. That order, Milord, 74 of 2016, I have NS page 15.
You have not taken any decision yet.
Not.
In terms of the directors, similarly situated land losers appointment claimants, the exercise was done. And Lord, the status was required to be furnished before your lordship, whether all the petitioners are eligible to be appointed or not. Now the status I have shown to your lordship, that is the status. No individual.
Where is it? Show us which order.
No individual order has been.
Then why not? How do you comply with the direction then?
that was the direction of this honorable court to file an affidavit. But that we have done. That is, I was keen to show to your lordship that what affidavit has.
There is a direction to file affidavit.
Accordingly, we have filed an affidavit. No individual order of rejection was passed in respect of any candidate.
আমাদের রিপ্লাইটা আমাদের সেই রিপ্লাইটা দিয়ে ফেরত আমরা এখানে বলেছি
Now, if I can draw your lordship's attention to initiate process. Now, I just take your lordship to my affidavit. Yes. To complete the exam within 3 months. That was the order. To complete. Complete. Yes. Yes, yes, Lord. I That will be direction. That's why what I am just. That is what but, I just two paragraphs I will show. Two paragraphs from my There's no direction. They're just not going to see us. No, I stand corrected. Not the exact language of the learned cat was just railway authority shall process the case of the applicant within a period of 3 months from the date of receipt of a copy of this order, and if they satisfy the requirements contemplated under the scheme dated 16 July 2010, appointment might be given to them. That was the order passed in one group of OAs. There were several OAs. Now, in another, this is not two groups of original. My affidavit. My affidavit. But if you takes my affidavit, yes. Accordingly, with the present way, all the ways cited above. In view of the direction of the Honorable High Court Supra and our revelations as indicated above, we feel it appropriate in the interest of justice to direct the respondents to undertake an identical exercise as directed by the Honorable High Court in WPCT 17. Yes.
Page 50.
Yes. Yes, yes. But not beyond June 30, 2029. Yes. Now, Lord, I tell if your Lordship gets the background of the case. No, the Supreme Court interview. Yes. 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 But as per guidelines framed by the Honorable Supreme Court, No, but Supreme Court framed the guideline. And in accordance, yes. This is arising out of SLPC number.
That was 1834.
But this is dated 14th March 2019.
Yeah.
No, in view of this guideline, we are no. Regarding age relaxation and other things. Right. That is stated. That is stated in the affidavit. No, but that is stated in the affidavit. But then kindly give me. I shall produce. No, that earlier, I tell you, Lordship. What had happened? I tell you, Lordship. Yes, Lord. No, I understand. But what has fallen from your Lordship, I fully appreciate. I fully appreciate and submits.
You
Is that-
produce the order closing the issue,
Yes.
then we'll see.
Yes. All right. I'm extremely grateful.
Yes.
Item number 28.
For the respondent. I appear for the respondent. I appear for the respondent, my lord.
Nobody is appearing for the petitioner. You are for the respondent.
I appear for the respondent. I do not know who is appearing for the petitioner.
Not today. None appears for the
Day before. December.
Item number 29.
Yes. My lord. Lord, I leave the chair on behalf of the
My lord, I am for the petitioner. I am led by my learned senior, Mr. P.R. Das.
Made. May. May it please your lordship. To resume my submission, before I interpret the word certificate occurring in the rules, my lord, I would like to submit some other documents. Lordship comes to page 122. The first one that I submitted yesterday, that was the request by the learned presiding officer of the Debt Recovery Tribunal before the government of West Bengal principal secretary. And the second one, this is the one that is the commissioner, that is the secretary of the Department of Commercial Taxes, his competent authority, my lord. He writes, sending herewith a letter received from the presiding officer, Debts Recovery Tribunal, Government of India, Minister of Finance, dated 2nd June 2016, and also a prayer of Sri Devashish Ghosh, Joint Commissioner of Commercial Taxes, now on deputation as Secretary Register under the said tribunal since 8/1/2014. I am to state that the presiding officer DRT1 Calcutta intends to extend the service of Sri Ghosh on deputation for 1 year for more than 8/1/2017. Sri Ghosh, JCCT, has also prayed for the same. Now he writes, this directorate has no objection if Sri Ghosh is allowed to serve as Secretary Register and the said tribunal on deputation for 1 year more with effect from 8/1/2017. So he writes it to the principal secretary, my lord. Of course, no reply comes from the principal secretary. And of course, at page 123, the presiding officer addresses a letter to the same secretary, Vinod Kumar, that is commercial taxes. And I skip that. And my lord, this third one, 125, assistant register, he writes to the registered debts anyway. That is 126, my lord. That is also noteworthy. This is the this is the presiding officer. He writes to the joint secretary of the central government. He writes, Sri Ghosh is preparing his job very efficiently and sincerely with full dedication. He is having an ability to shoulder responsibility and leadership quality which helped in improving the function of this tribunal. In the above circumstances, Ministry is requested to allow Sri Ghosh to continue his deputation for the post of secretary beyond so and so. Of course, this letter has not been given, a copy has not been endorsed to me. Now, Lordship comes to, now I take your Lordship to page 48. The last letter, after the controversy arises, and that comes from the Secretary of the Commercial Taxes Department. That is important before I go for the interpretation of the word certificate. 48. Milord, here he writes, I am reading from the second paragraph. It appears from our records that a series of correspondences were made earlier explaining the recovery as required is not tenable under Central Civil Services Leave Travel Concession Rules 1988. Even on a cursory look in Rule 2.1 of the rule EBIT, it appears that LTC admissible to employee under a state government and
who are on deputation with the central government on two conditions as below. Number one, completion of continuous service for 1 year that he had. And the second part is important, my lord.
Yes.
Subjective presumption of the appropriate administrative authority to the effect that the employee concerned is likely to continue to serve under the central government for a period of at least for 4 years. Now he writes, it is quite clear.
You had given us this provision yesterday. You had shown us this provision yesterday.
Yes, my lord, that is rule 65, page 65, 66. That is the LTC rule, your lord. I would like to explain the word certificate there. I don't think.
Page 65, 66.
After this, my submission will be that. Actually, I want to submit one para here, and thereafter I will go to that, my lord, page 65, 66. He further writes, my lord, it is the opinion of the state of West Bengal. It is quite clear that neither the administrative authority nor the incumbent might have been knowledge regarding the continuity of deputation at the time of sanction of the LTC. It appears that a legal fiction exists here which needs proper interpretation as implied in the rule. This is important, my lord. Here, of course, then I come to page 182. Let my deputation order I want to refer to, my lord, page 182. That is important. What happens when a legal fiction arises? We have some answer from here. 182 plus, that is my deputation order. Lordship, my lord got it. The governor is pleased to release Sri Debashish Ghosh and Srimati Sonali Mitra, both presently working as Deputy Commissioner Commercial Taxes West Bengal under this department from their present post as Deputy Commissioner Commercial Taxes Directorate, to enable them to join their assignment to the post of Secretary Register of Debt Recovery Tribunal Kolkata 1 and Debt Recovery Appellate Tribunal Kolkata 1 respectively on deputation basis. Now, their pay and allowances and their terms and conditions of deputation will be regulated in accordance with the Department of Personnel and Training OM number so-and-so, dated 17/6/2010, as amended from time to time with effect from the date on which they relinquished their due charges. Of course, DOPT, my lord, Secretary DOPT is implemented as respondent number 8. Now, lord, it comes to page 2, paragraph 7.6. Next one is the order of the DOPT. This regulates the deputation. Transfer on deputation, subject, transfer on deputation foreign service of central government employees to ex-cadre posts under the central government, state government, so and so. Regulation of pay, deputation, duty allowances, tenure of deputation, foreign service, and other terms and conditions regarding. Page 180. Now 7.6. 186. 186, lordship comes to. Now 186. Paragraph 7.6. Lordship comes to paragraph 7.6 at page 189. That is important. I am placing it. Admissibility of allowances and benefits while on deputation foreign service. Such allowances as are not admissible for regular employees of corresponding status in the following organization shall not be admissible to the officer on deputation foreign services, even if they are admissible in the parent organization. Following allowances will be regulated with mutual consent. The word is important, my lord. mutual consent of the lending and borrowing organization, HRA, and comes to 4, LTC. Now, I specifically placed before the learned administrative member consisting single bench that it pertains to LTC, and that has to be decided mutually. If any controversy arises, that has to be settled mutually. So naturally, it should be placed before the division bench, or the government should be directed to have a mutually have the matter settled. But of course, that petition goes and we come here before your lordship. Now, my lord, as regards the now, my lord, the rules now come. I'm shortening my case, my lord. In the case of persons belonging to categories mentioned 1, 2, 3, and 4, also 3, Rule 1, the leave travel concession shall be admissible on completion of 1 year's continuous service under the central government, and provided that it is certified by the appropriate administrative authority that employee concerns is likely to continue in service under the central government for a period of 2 years, in this case. Now, the word certificate appearing here, certificate on completion, serve under the central government for a period of 2 years. In the case of leave travel concession, hometown at least 1 year for the leave travel concession only. And he satisfied all that. My lord, the certificate that is fell from your lordship the other day. I say, my lord, I say the probability and certificate is a certainty. I mean, a certitude. They cannot coexist simultaneously. If we talk of any certificate, of course, I don't think anybody can give it. Presiding officer cannot give it unilaterally. He's a borrowing organization. How can a borrower say that he is likely to continue for so many years? So what I say, my lord, and I said, and the other day I said, there is no pro forma of any certificate.
The borrowing entity can say if he is likely to continue.
My lord, here, my lord, of course, I have my thoughts. It has to be countersigned by the governor.
The borrowing entity.
He's simply a borrowing organization. Supposing he writes today, he's likely to continue, and supposing the deputationist organization says, "I come back,"
he will say he's likely to continue if the conditions contemplated in provision 8.2 of the OM that you are reading exist. Come to 8.2 at page 190. You can't say that because he is borrowing, he cannot say he is likely to continue. He is the only person who can say that he is likely to continue. No other person can say that he is likely to continue.
That is what I am.
Please read it. This is contrary to what you are submitting. Don't say that is what you are saying.
Yes.
It is the ministry or administrative ministry or borrowing organization may grant extension.
That is exactly.
So it is only the borrowing person who can say. You say borrowing person cannot say.
That is exactly.
The rule is contrary to what you are saying.
My lord, I bow down to your lordship.
Yes.
I saw it, but I can remember it now. That is exactly what I am going to play.
Either you knew that he was going to continue, or you knew that he was not going to continue.
No.
So you can't say that the borrowing entity was not in a position.
That is exactly what I was going to place it.
Yes.
I was going to place it. The section has to be interpreted.
That can be extended up to 4. He has availed the leave between the first April 12 days. Also taken leave advance. He has applied for this in February. Show you. Applied for February and received on 22/16 from this petition regarding he is working think there's. What is the date of his deputation order?
Date of deputation is, my lord, 8/1/2014. With effect from 8/1/2014 it comes.
8/1/14. Where is that?
It is of course 180.
182.
182. He joined on 8/1/14, and he was there on 8/3 up to 8/3/17, my lord. 3 years and 2 months. And of course, the secretary, of course, by that clause, my lord, I think 8.2, it was the secretary was the competent authority of the department. He endorsed.
He was from 8/1/14 till when he was there?
8/3/17, 2 months leave. He was sanctioned by the learned presiding officer. Thereafter, he
So
joined on.
he was there for 3 years.
My lord, that actually
He was
officially
there for 3 years as is contemplated in OM of 17.
he was there for 3 years, and 2 months leave was given by the learned presiding officer. So he joined on. He was there, my lord. Officially, he was there for 3 years and 2 months.
Yes.
Yes, 2 months. And my lord, that was what I was going to interpret it. That
there is no question of interpretation.
That was the subjective
question of
satisfaction of the learned presiding officer.
So whether he was correct or not, that we have to see. That is what.
My lord, that is, and that is why I said that matters. Of course, here, of course, rules of business of the single bench administrative member. I have said it, my lord. I have placed it before your lordship. 237 and 238. So that is the central tribunal, my lord. Deputation, appendix 8 at 237. This is the division bench matter. Deputation. This pertains to the laws of deputation. Actually, that the law, that is the DOPT circular, that has to be taken care of, my lord. And of course, and we prayed before the authority that it should be placed before a division bench so that we can. Actually, my ultimate ambition was, aim was there, my lord, that the matter be settled mutually between the two governments. That part we are not. Supposing he did it after 2 years, he got it. He leaves the job. What happens? There is no specific rule how to return the money. Already said, already sanctioned, duly sanctioned. I said the word duly sanctioned by the, as it fell from your lordship. I duly sanctioned when the presiding officer is the person who had duly sanctioned the money. But how it is to be returned?
Where is the order of the tribunal?
Tribunal's order is, my lord, at page 158 to 168. That is the order, and review order is 193 to 201.
You have also filed a review.
Review, my lord. Actually, in review, my aim was to see that it is taken up by a division bench, my lord. Because so many judgments of this court are there, learned administrative member sitting singly, he cannot decide issue. And the matter related to substantial question of law, my lord. The deputationist organization and the lender and borrower, they can decide what part of the, even I also said that there may be proportionate share may also be there. They will decide among themselves. I do not know, my lord. But
what you are submitting is not the intention.
No, it is for the, my lord. I just bypassing.
That mutual is for passing a regulation. No regulation has been framed mutually. That is not for deciding a case to case basis whether something will be given for that as state and central government will sit together. That is not the intention of the provision.
It is for them to mutually, my lord.
No, it is not. It is for them to mutually agree to a regulation or rule. If there is no such regulation or rule mutually agreed,
arises mutual consent.
it is not to be looked into on a case to case basis. That is not the intention of the provision that you are reading. It says may be regulated mutually means a regulation may be framed or a rule may be framed mutually. It doesn't mean that everybody's case, one central government and state government officer will sit and decide whether he should get an LTC or he should not get.
But he is, of course, entitled to the LTC for the block year.
That we have to see whether he was entitled or not.
And, my lord, one more thing that I have to submit, my lord. since his appointment in the department in 97, until this day, he has not taken he has not availed of any LTC so far.
Yes, you are relying on some decision that single judge cannot hear in the tribunal.
The last one, my lord. Minto, my lord, के?
Yes, you are appearing for the respondent.
No, I'm appearing for the union opinion.
Only on this point. We are asking.
That's not been handed over. It speaks of that the single bench cannot decide.
That is all. We are not going to go into the merits. It speaks of what is your submission. It is in terms of L. Chandra Kumar judgment, or it is not in terms of L. Chandra Kumar and the provisions in the Tribunal Act.
Lord, as to this judgment, my lord,
You have
speaking of that, this single bench cannot decide this issue. That's there, my lord, in the judgment. I cannot not go against.
In the-
cannot submit anything, my lord, because this is what has been spoken of. It's a technical issue, my lord. Your lordship will decide. This is the division bench judgment, and that has been passed by the administrative. Let me see, my lord. Because it speaks of that administrative member cannot see. That has been passed by the administrative.
Yes, it appears in this case also.
Lord, that I have to see, my lord, the judgment is that 158 and 190.
No, it says at the very top. See page 158. Just below the date of judgment.
Administrative. My lord, but that is it. Here, my lord, I would only refer subject to a lordship's correction, my lord, that there are which provides of the division bench cases and
No,
the
once we
single
find
bench
that the tribunal was competent, then only we'll get into the
Lord,
merits.
if your lordship kindly looks into it, it is subject to a lordship's correction, my lord. My lord, if your lordship kindly takes up page 237. My lord.
No, no, what we are saying is only if we find that the tribunal was competent to decide it by a quorum of Then
In that
only,
regard, I am only answering to that regard, my lord. I am referring to page 237. My lord, here, my lord, it says Central Administrative Tribunal rules which have been annexed. My lord, if your lordship kindly see, the first page speaks of in the middle portion, Appendix 7, Rule 154C, subject-wise classification, what are the division bench cases? That has been referred. Then, my lord, if your lordship kindly turns to page 238, my lord, subject-wise classification of cases, single bench cases. And if your lordship kindly comes to K, my lord. K, grant, refusal, or recovery of allowances. So, as per this rules, my lord, subject-wise classification of the case, single bench case, my lord, it speaks of that the grant, refusal, or recovery of allowances is a matter of the single bench. Have your lordship found out?
and where are the division bench just before that?
My lord, just before that, page 237. These are the, my lord, divisions bench jurisdiction, and this which division bench will, my lord, adjudicate. And 238 speaks of, my lord, what are the cases which the single bench will be adjudicating upon. And these consist, my lord, K, grant, refusal, or recovery of allowances. Where that case relates to the grant, refusal, or recovery of allowances has not been spoken of so clearly.
That is not apparent from the judge order of the court.
Yes. So, my lord, whether that judgment consists of the division bench matters or it consists of a single bench matter is not very clear from the judgment. With the case of
Practice rules, there is a rule 18 also. This is only extract of the schedule. The rule in practice rules from which this schedule has been taken out.
your lordship allows me to come back after considering this order and the rules itself. I'll try to assess my lord considering this.
Yes. The learned counsel for the petitioner.
Judgments are here, of course.
After 1 week, yes. After
কি বললো কি বললো
after 1 week, movie day. Post it on 9th.
Item number 30.
My position.
আরেকটা effectively দেখলে আগে। My lord, the petitioner before your lordship, my lord, is the original applicant, my lord, for the learned tribunal. My lord, I have been, my lord, instructed, my lord, that there has been an order of this honorable court, my lord, that I have also, my lord, come across about the, my lord, effect of an order, my lord, which is passed by the learned administrative member of the tribunal. My lord, here also, my lord, this has been, my lord, passed by the learned tribunal, though. However, so, my lord, only administrative member, yes. May I just look into the judgment once and come back to your lordship with this? Because I have said the honorable coordinate bench of this honorable court. I actually, my lord. So, my lord, I'm sorry, my lord, I ought to have been. My lord, it is item number same as item number 6, I have been told. Same as, I'm sorry, my lord. I've been told, my lord, it is item number same as item number 4 of today's list, my lords.
Just now.
Oh, acha, acha. Basa, yes, ma'am. নাম্বারটা যদি বলেন আমি দেখে নিচ্ছি। দেখি। দুশো একুশ 221 of 2024. Yes, my lord, I've got that, man. 2024, my lord. As your lordship, please. I'll do that, man.
Case of L. Chandra Kumar, whether there is any observation in this regard.
Lordship, I'll just go through and just try to assist your lordship. Grateful.
Not today. Because the rules of practice, there are section, rule 18 and rule 154. We were just going through it. I'm not restricting you, you may see otherwise, but we could see two rules relevant to this aspect.
And is my lord this passing in your lordship's mind that about the judgment of the Honorable Supreme Court about the effect of the judgment of the particular court which judge has, which is already passed earlier, will be after, before declaration of that particular order?
No, all these matters are after 97.
Yes.
So they are covered by L. Chandrakumar.
Yes. Yes. My lord, I'll just go through and try to assist you.
Because prior to that judgment,
My lord. My lord. My lord. I follow, man. I follow your lord. I follow your lord. Grateful.
Item number 31.
Thank you.
My lord, there are three can application before Lordship, my lord. Interim order is going to expire tomorrow, my lord. As said, my lord, I am interim order may be extended, my lord.
Objections may be recorded in regard to my learned friend's submissions.
From time to time, interim order was extended, my lord. Yes, my lord. First, my lord, I would like to invite unforced tribunal pertaining to disability pension, my lord, and the policy.
granted to you.
No, you are for the. We are for the Union of India, my lord.
Oh, so it has been granted in favor.
On the basis of judgment and on the basis of policy, which was not existing, my lord. The policy is not existing.
Disability pension.
Disability pension.
Peacetime or in the.
No, I'm not going on peacetime, high time, my lord.
Yes.
The policy which was referred by the Armed Forces Tribunal, which is not existing, my lord.
So what is the nature of disability? That
Nature of disability, my lord: hypertension, lifestyle disease, obesity. In similar matter, my lord, Supreme Court remand back the matter to the Kerala High Court to decide this issue, whether this disability comes under the disability or not. I have, on the last occasion, I referred the judgment, my lord, given the judgment.
What is the opinion of your release medical board?
Release medical board is neither aggravated nor attributed. One thing important, my lord.
So that was appealed against.
Yes, my lord. They filed appeal, first appeal, second appeal, that was rejected.
All exhausted already.
All exhausted.
Then why the tribunal has, let us see the order.
Page 128 of the second paper book, my lord. There are 2 volumes, my lord. Second volume.
This is the first case, my lord, in India. Your lordship going to decide, my lord. No. Regarding
Contradict to my learned friend's submissions.
before going to the impugned order, my lord, I would like to submit, my lord. Applicant was enrolled in the year 1988 and he was discharged on 31st October 2014 on the completion of terms of engagement, my lord. He was not discharged on the medical ground. He was discharged after the completion of terms of his engagement. Simple retirement, my lord.
He was in the short service.
No, completed full terms of after completion of full terms of their service, my lord.
So he is not released by virtue of the disability.
No, my lord. He was discharged after the completion of terms of his engagement.
Is that fact in dispute?
No, not.
Yeah. My lord, may I read, my lord? Impugned order, page 128, my lord. Wrong rules, wrong judgment. I'm not saying wrong judgment, my lord. That judgment is not applicable because the I'm just reading my one thing, my lord. Yes, my lord. Not applicable. My lord. Mother judgment is, my lord, Dharamveer Singh, my lord. Dharamveer Singh versus Union of India, where the benefit was granted to the applicant, my lord. Kindly see the judgment, my lord. On the face of the judgment, my lord, the rules referred, my lord. Entitlement for casualty pension and award for armed forces. Last occasion, I have given, my lord, on the yes, my lord. Huh? No, item number 3, WPCT 4. Oh.
So that gentleman was discharged upon superannuation.
Upon superannuation. No. In Dharamveer Singh case, applicant was discharged on medical grounds.
So therefore, factually, it is different.
No, my lord. In this impugned order, Honorable Tribunal referred the case of the Dharamveer Singh.
Therefore, on that ground alone, it is inapplicable.
Yes, my lord. It is not applicable in this
It
case.
is not in dispute that he has
Superannuated.
superannuated.
Yes,
It is
my lord.
nobody's case that he was discharged on account of any disability.
Yes, my lord.
So therefore, this judgment on that point itself, it is distinguishable.
On the basis of this judgment, my lord, armed forces passed the order.
How many times you will say that?
Yes,
That we
ma'am.
have understood. What we are saying is that itself will, because Rule 9, which has been quoted, you see sub Rule 3 of Rule 9. What
Rule
it
5
says.
also quoted, my lord.
No, Rule 9, see Rule 9(3). It is quoted at page 132 of the second volume.
132.
The disease which has led to any individual's discharge or death will deem to have arisen only if it has led to his discharge.
Discharge.
Plus, there is no reason in the order. Just 3 judgments have been quoted and give it to him.
Let my learned friend finish, my lord. I shall make my submissions there.
Yes.
Kindly for a moment, my lord. Kindly see pension regulation for the army 2008, my lord. Pension regulation for the army 2008. We have given, my lord, on the last occasion. (2008). Pension regulation, pension regulation for the army part 1.
Which provision?
Page 3, my lord. Para 2, my lord. The regulations in this part supersede the regulation in pension and regulation for the army part 1 and part 2 1961. That has been superseded.
Yes.
It has been effected on and from 2008.
1st July 2008.
And the applicant discharged in 2014.
So this was applicable.
This was applicable. We have stated in our counter affidavit, but Honorable Tribunal did not consider that same.
So where has the tribunal taken into consideration the provisions of the 61 rules?
Yes, my lord. Page 1, my lord, page 131, my lord. Page 131, volume 2. Para 7. The issues which need to be addressed before deciding outcome of this application are twofold. First, is the applicant eligible for disability pension? Para 4 of entitlement rules for casualty pensionary award 1982. This has already been superseded by, my lord, by 2008, my lord.
No, this is of 82. That what that you read has superseded 61.
No, 82 is the appendix of the 61, my lord.
It is also part of
the 61. Paragraph 4 entitlement rules for casualty pensionary award 1982 states as under. Invalidating from service is necessary condition. Here is not invalidating from service, my lord. Here he is retired.
Who stopped you from pointing out to the tribunal that this is not
My lord, in the counter affidavit, we stated that policy 2008 is applicable. We have annexed, my lord.
Why didn't you point out to the tribunal?
My lord, point out, but did not consider in our counter affidavit when we have stated in written, my lord.
Oh, you have given it in your
In writing, my lord. In not one matter, in several matters.
We can't conclude today.
My lord, one indulgence, my lord. Interim order is going to expire tomorrow, my lord.
Well, that you have already said. How many matters are there?
3 matters, my lord. There. Not one matter. My lord, there are 9 also same issue.
Let us decide this.
Very well.
The others will follow. The you are appearing in?
My lord, I am in there 31 and 32. My learned friend on VC, my lord, he is in 34.
33, my lord, 33. And it is part heard, my lord. I had given the judgments, all the 4 judgments I had handed over, my lord, to you. And also, my lord, I had also given a Chandigarh High Court judgment wherein it has been dismissed, hypertension case. Now there is a Delhi High Court judgment also where this is dismissed, the hypertension case.
All these matters will come up on 6th of January.
Very well, my lord.